I got Mrs. Layfield checked in. I would like to know who's on that LGK 20 plus. You can unmute yourself and state your name, please. The gentleman on the LGK 20 plus, you want to speak?
Yes, sorry. My name is Cortez Green.
Say that again, I'm sorry.
My name is Cortez Green.
I got you, Mr. Green. Good morning to you.
Good morning to you too, Your Honor.
I'm going to ask you to mute yourself again, and I'm going to ask everyone to mute themselves until their names are called. And then I have one more before we start is Aaron signed on. I don't know what your last name is or if that's even your first name.
Your Honor, that's my client, Aaron Latisminsky, the defendant who I just emailed you the report on.
Okay. Good morning to you, Mr. Latisminsky. And then one more, Galaxy Note 10 plus 5G.
Jonathan Goodwin.
Jonathan Goodwin. Good morning to you, Mr. Goodwin.
Thank you. Good morning to you, Your Honor.
And I don't see Mr. Jonathan Goodwin on this document.
I had an appointment on Friday. I had a lot of technical issues trying to get signed into the right meeting. I had called your telephone number, and the lady on the other end of the phone for Judge Perkins said I should call in this morning. She had my file set aside. She said she just was on the bench.
Very well, Mr. Goodwin. Can you mute yourself? And then lastly, let's find out who this person is. Lasker?
Yes, how you doing?
Very well. How about yourself?
I am okay. Glad to make it on time.
And let me ask you a question, sir. What is your last name?
Oh, mine?
Mr. Lasker, yes.
Yes, that's my last name. My first name is Nuralam, last name is Lasker. Nuralam Lasker.
Oh. All right, it's on you. Good morning to you, Mr. Ross.
Good morning, everyone. Court is now in session with the Honorable Judge Sean B. Perkins. While court is in session, please keep your backgrounds quiet and clear. Sit back when your names be called. And also, if you're in a vehicle, there's no driving while court is in session. Also, no laying down, smoking, eating, drinking, gum chewing, or walking around of any kind. Thank you. Good morning, Your Honor.
Okay, good morning. Good morning, everyone. Let's just start with Mr. Latisminsky. I think he's got some very good information that he can bring to the court and to everybody that is potentially watching on YouTube. And I would really like to hear Mr. Latisminsky's story.
The only issue, Your Honor, is that it's Mrs., not Mr.
Oh, I'm sorry.
That's right.
Okay, I'm sorry. All right. Mrs.
Okay.
Story.
Good
Why
morning.
did I? Okay. Good morning to you, ma'am.
Morning.
All right. Let's see here. Well, just to tell you, ma'am, I'm particularly bothered by the nature of the allegation. Speeding 26 to 30 miles an hour over the speed limit on a city street. Be that as it may, your attorney seems to have worked out a very good deal for you. But that deal is going to be conditioned on whether I choose to accept it or not.
Okay.
And part of that acceptance, or lack thereof, would be that you come with some very compelling information about what you learned in the Michigan Defensive Driving course, and particularly, obviously, as it relates to speeding, but also as it relates to something that you actually didn't know about driving, and that's some information that you can provide other people that may not know. So with that being said, I'm going to call the case of the city of Detroit versus Aaron Michelle Ladisinski, case number SP118741, counts 1 and counts 2. Appearance for the record, please.
Morning, Your Honor. Corey Silverstein appearing on behalf of the defendant, Aaron Michelle Ladisinski.
Okay, and Mrs. Ladisinski, or Ms. Ladisinski, can you put your name on the record, please?
Yes, my name is Erin Michelle Ladisinski.
All right, very well. So today is the date and time set for a pretrial in this matter. It is my understanding that Mrs. Ladisinski, or Ms. Ladisinski, you have, your attorney has, like I say, negotiated a very good plea deal in this case, very good plea deal. And I am in receipt of the certificate of the Michigan Defensive Driving course. I'll congratulate you on completing that course. We think that course is pretty well. I think that everybody could benefit from that course. So with that being said, ma'am, I'm going to let you have the floor, and you can tell us exactly what you got out of that course.
Okay. I'm going to say yes, Judge. I do agree with you that everyone could benefit from that. I think it would be cool if Michigan even required drivers to take that course every 5 to 7 years. It's just a really good refresher on driving law knowledge, things that you're going to forget, how to anticipate dangerous situations with aggressive drivers, weather, construction, etc. I think aggressive drivers kind of hits a little closer to home, especially living in a city. You see a lot of that. People, tailgating, and it taught me some things that I could do to not involve myself in situations like that, and prevent road rage, because that, I think, is something I see a lot in Detroit. In regards to what I was pulled over for in a residential area, after taking the class now, I do understand the danger of speeding in a residential area. And I think it hits a little closer to home for me now because I am a new mother. I have a seven-month-old baby, and when she's going to be walking around, kids don't have the wherewithal to understand danger. So it's important for the people that have a driver's license and are operating a vehicle to make sure they're following the law so they don't hurt a child, as well as people walking. You're allowed to have that freedom to walk around your neighborhood, and you should feel safe without someone speeding past you. As well as cyclists. I'm a biker myself, and so I do understand the irritation of people driving fast, even past me. I like to ride my bike around Belle Isle and up and down Jefferson, and it can be scary. So I don't want to be involved in hurting somebody. So I think that it, opened your eyes a little bit to take the class.
Okay. Well, let me say this, ma'am. Mr. Walling, are you there? He's in, he's in breakout room. I'm going to say this about speeding. And you mentioned some things that open the eyes of you as far as speeding is concerned. Congratulations on your newborn child.
Thank you.
But and Mr. Walling got on me. He's our house counsel, and I particularly look at this nature of this offense. And he told that I need to watch what I say, but I'm going to say it anyway. This is when I see somebody going this fast up a city street, I always think about, you know, their shit is just more important than everybody else's. And I'm glad it sort of hit home. And good morning to you, Officer Robinson. Very good to see you, sir.
Good morning, Your Honor. How you doing today?
Yeah. So I'm glad that it hit home for you. I hate to see that it took this to get to that point, because there were a lot more mothers, a lot more bikers than you before you decided to speed or got caught speeding. So I say that, but Mrs. Ladisinsky, I'm gonna also say that we're not that quite there yet on what you could be able to bring to this court in order to take advantage this very, very handsome deal your attorney has negotiated for you. So we're going to need some more information regarding other things that you learned out of this course that you could bring to the public.
Okay. There was a pretty lengthy section on drinking and driving. That was, you know, I used to bartend for quite a while, and basically in Michigan, even a bartender can be held liable for over-serving alcohol. But I think it's really important to be able to judge if you can drive a vehicle. You know, it's basically 1 drink an hour if you're, you know, a standard 180-pound man, 150-pound woman. And I think, you know, a lot of people definitely ignore that, because there was a statistic, 1 in 130 people actually get arrested for drinking and driving in Michigan. And it's anticipated that they actually drank and drove over 1,200 times before they got caught. So that is something that kind of, I don't know, it was a bothersome section, because it was 2 full sections that took about 2 hours just to study drinking and driving in Michigan. And it's uncomfortable because so many people do it. And I have actually lost a friend to drinking and driving. So something that I don't do, but I know a lot of people that do that. So it's very scary. And it's very dangerous to basically be driving between the hours of 12 and 5 a.m. are the highest chance to be encountered with a drinking driver. So
let me ask you this, Ms. Ladisinsky, did it speak on any statistics on speeding before getting caught?
That I don't remember seeing a statistic on.
Okay. What about did it speak on about any of the signage that you may have forgotten about, not know about?
Yes, there are many different signs for drivers. And then there's the triangle sign with the 2 kids on it that will tell you that you're in a residential zone or a school zone. Obviously, speed limit signs, the yield signs. If you come up to a blinking red light in a residential zone, you're required to stop and treat it as a sign.
Okay, so we have Officer Robinson on the line. He is the officer that wrote the tickets. I want to give him an opportunity. First of all, put your name on the record, officer, with your badge number, please.
Yes, sir. Officer Willie Robinson, badge 2590, Detroit Police.
All right, good morning to you. And,
good morning.
Is there anything you would like to add, Mr. Robinson, to this dialogue? I know you probably signed on and you heard most of what Ms. Ladisinsky had to say. Would you like to have anything to say, sir?
Just that within the city of Detroit, we see a lot of speeders, a lot of people doing 50, 60, 70 miles per hour in these 30 and 35 mile per hour zones. And I just feel like, for whatever reason, people feel like when it comes to the city of Detroit, people feel like it's fair game. People feel like the rules don't apply. They can do what they want to do, and there's going to be little to no repercussions. That's how I feel. I mean, I get people doing up to 70 miles an hour down these 30 and 35 mile per hour zones, and I see that quite often, Your Honor.
Just 1 second, everyone. We're having some technical difficulties.
I open up a room, I'm gonna always go into that breakout.
Lose the judge?
They're having some technical issue.
I'm sorry about that. You were saying, Officer Robinson, that what I last heard was that you're in the city of Detroit on the city streets and people are going well over the speed limit.
Yes, sir. Quite often, I see people, there's no speed limits in the city higher than 35 miles per hour. And quite often you get people doing 50 is common, 60 or even 70 miles per hour, double the speed limit is quite often. And I feel like when it comes to the city, people feel like it's fair game. They feel like the rules don't apply when it comes to the city of Detroit. And then when they get to the suburbs, the rules do apply. So I feel like they feel like maybe it's little or no repercussion, or I don't know what it is, but I see this quite often. In her case, she was doing 56 and a 30. That's pretty dangerous.
All right, and in your understanding of the law, at what point does that become a potential of reckless driving offense?
Well, for reckless, you have to have more than one offense, but as long as you have 3 or more offenses, it can be reckless.
Okay, very well. I'm going to put you in a breakout room with. Let me do this so it doesn't. Let me try and do this again. I'm going to put you in a breakout room with Attorney Goss. I'm going to put you, Attorney Silverstein, in a breakout room with Attorney Goss, and I'm going to put, so that you guys can discuss it. You have stated off the record, Attorney Silverstein, that there was an offer already available to your client based on her taking the class and her performance in that class. So I've assigned a room.
Just me and Robinson right now.
Okay, so Attorney Silverstein, do not join that room right now. He wants to speak with his client. So what we'll do is we will pass this matter until those parties have to speak, and then we'll move forward. Ms. Ladisinski, I appreciate the dialogue you brought to the court, and if you give the parties a minute to go over the situation one last time, then we should be able to get you out of here pretty quick.
So, Your Honor, I have a square popped up on my screen asking me to join that breakout room. Should I decline that?
No, just wait a second. Just don't do anything yet, Attorney. When you get ready, when Mr. Goss, if they want to speak, then you can just hit that button. But if that's not necessary, then you just don't do anything at all.
Okay, I'll just stay with the box.
All right.
Judge, I have to speak to Mr. Goss after he takes care of these high-priced lawyers.
Okay.
And then, is there anyone else to talk to at this point?
No, you spoke to Mrs. Gore.
Yeah.
I was just gonna call her case.
I gotta talk to Mr. Goss first.
Okay, so I'm gonna put that matter aside. Let's see what we have next.
Oh, by the way, Judge, on that Gore case, she tells me she has a motion to set aside a default on a civil infraction arising out of this incident. Maybe we could put all this stuff together.
Well, I appreciate the fact that she probably, I don't know if you hand wrote a motion or filed a motion to yourself, Mrs. Gore, but I would routinely grant those motions based on the fact that this was had during the pandemic, and the court recognizes that, and it went along with the civil infractions, I mean, the other misdemeanors that were had at the same time. So I'm not too much concerned about that. I would have no problem granting that motion.
All righty.
All right. So let's move on. Next up is Mrs. Layfield.
Yes, sir. Good morning. How you doing?
Good morning to you now.
1, 2, 3,
Let me
6, 7, 8. I count 9, Judge.
Yeah, hi, Judge. I had a problem within the probation department. A few of the officers wanted me to give testimony in regards to trying to get an extension on the sentencing date because we don't have enough time to do the assessment.
Okay.
And Madam Clerk wanted me to go on record with it. It only take a minute.
Okay. What case are we talking about?
Yeah, it's not on the docket for today. I don't mean to interrupt the courtroom, but in order to have efficiency, we need an extension on this particular case. That's all we need. You probably don't go on record. I made a few notes for you.
I object, Your Honor. Good morning, Mr. Scott. How are you?
Oh, good, good. Good seeing you again.
All right. This is
the city, right?
This is the City of Detroit versus Brittany Ann Gate. Case number Z8073121. Please put your appearance on the record.
Yeah. Judge, my name's Ken Sciatti. I'm a probation officer here on the court. I'm going to represent the probation department on this matter. In this particular case, we are requesting that we can get an extension on this court date, the sentencing date. And the reason why is the extension is the probation department needs more time in order to contact the defendant. We don't have a good contact number, and I was hoping that perhaps Madam Clerk could get a phone number or a proper address so we can reach out to the defendant in order to do a proper assessment. So therefore, basically, and this is important because she blew a .31, and we want to make sure that everything is accurate in our department. We're hopeful that we can get an extension on this case.
Okay. Normally, I wouldn't grant an extension because it's important that this person gets some finality to their matter. And the sentencing date here I'm reading is set at 8/20/2021. But from what I understand is you haven't even had an opportunity to interview this individual.
That's correct, because we don't have a proper phone number and the address, we're not so sure it's good. And due to time constraints, we don't want to put the court in a lurch. So we were requesting more time to get the contact information from the defendant. We have to send out letters. We got to set up interviews. We got to write a report, and we're requesting more time.
So do you have an address at all? Well, I have an address on here.
We have an address, but I was hoping that there could be other addresses in the file.
Did you send something to this street address?
That's correct. And
return
right. And then there's notes you'll see that we tried to reach out by phone and we couldn't get a hold of the defendant. It's not my case, but I'm representing the probation department.
Mr. Walling, do you have any thing to say about the extension of that case? I know you don't have much information in front of you. It's not on our docket today, but you heard.
I have absolutely no objection to that, Your Honor.
Mr. Goss, I see that you came in the room probably on the tail end of it. The probation department has a case that's set for sentencing for Mrs. Brittany Ann Gayton. Its sentencing is on 8/20/2021. It's my understanding, based on what Mrs. Sciatti said, that there's been no contact with the defendant after numerous attempts to mail and to try phone numbers, and they transposed the numbers a couple of different ways. They haven't got any response, so probation department is asking for an extension of the sentencing date. Any objection to that, sir?
Your Honor, is the defendant in the courtroom now?
No, let's put your appearances on the record, please, Mr. Walling.
Okay, Philip Walling representing, well, not representing anybody in this matter because they're not here.
All right. And your P number, sir?
35229.
All right, and yours, Attorney Goss?
Dante Goss, may it please the Honorable Court, Dante Goss, P60162, on behalf of the city of Detroit.
Okay.
Your Honor, I don't have any objection for a adjournment. However, so this motion is is brought up from the probation department. Is it looking for the extension?
Yes, probation department tried to get in contact with the defendant, and they haven't been successful in that. They believe that she probably potentially moved, or the wrong phone number has been somehow translated to them. And based on that, sentencing date is next week, and there's no contact. They haven't had a chance to draft a report because they haven't gotten in contact with the defendant. So I wasn't inclined to, I don't want to grant an extension necessarily without the person being here, but based on what the information I'm given, there's not going to be a sentencing on that date anyway, because there's no report and there's been no contact. So,
Your Honor, in that regard, instead of just blankly giving an extension, can we just note the file that probation asked for it if she shows up for sentencing date? Then we would give the extension at that point in time.
I got no problem, Judge, with something like that. What we're trying to do, Mr. Goss, is do a proper assessment, because it's mandatory by the state of Michigan that we do it. And we want to make sure that all parties are involved are on the same page. I just don't want the defendant to, she's notified. That's why we came in, because due to time constraints, we just can't do the report.
Right. I understand that. That's fine. I just want when the defendant comes in on the 21st, that we can get all the relevant information at that time, and then we can extend it out. So it's a little cleaner.
Comment, please. Mr. Sciatti, what would be the easiest for you and your department to do?
It's very easy. We get like a 3-week extension, and we do the paperwork all over again, and it's a done deal. And then we'll notify Madam Clerk will notify of a new court date, and it's basically a very, very simple procedure.
Let's just make it easy on all the parties involved here and do what Mr. Sciatti wants. We'll fight with Mr. Sciatti on another day.
My objection is that if we can't get in contact with this person in 3 weeks, we don't waste 3 weeks. So, at least it's when the person comes in, we can give her the 3 weeks notice after that point, once we get the correct information. If we get 3 weeks right now.
That's fine.
Let me stop you there, Attorney Goss. I'm gonna deny the probation department's motion to extend the time it is, if she shows up next week, we can get the proper information from her.
That's fine.
Then if not, then we'll put a bench warrant out for her arrest. And then we'll have the Detroit police or whatever agency, when she gets picked up, then if she gets picked up, then we'll deal with it at that time, all right? So based on that, motion is denied. We'll see you back on December the 20th, on August the 20th at 8:30 a.m.
That's fine, Judge. And the attorney's right. We can get the proper information from the defendant at that time. Okay, thank you.
All right, let's go. Mr. Goss, did we find some kind of resolution to Ms. Ladisinsky's?
Yes, Your Honor. I just need to talk to Attorney Silverstein about it.
All right.
Your Honor, you're prompting me to go into room 1. Is that to talk to Mr. Goss or?
Yeah, you wanted to speak to Mr. Goss regarding Mrs. Gore's file, right?
Yes.
So you can all go in that room.
All right, thank you.
All right, thank you, Your Honor.
And Judge, is it possible for me to have the name of the young lady in the case we just did? Is Brittany Ann? I didn't get the last name.
Gayden, Gayden.
Thank you.
Your Honor, I think Mr. Goss wanted to talk to me, but I
join that room now, Mr. Silverstein.
Breakout room 1?
2. 1, yeah.
Okay, let me try to go into that one.
All right. So. All right, this is the city of Detroit versus Shalonda Shanae Layfield. Case numbers SP 1124088, counts 1, 2, and 3. SP 1154900, counts 1 and 2 and 3. Case number SP 1154923, counts 1, 2, and 3. In case number SP 115507661. Mrs. Layfield, yes, I have, ma'am, you're going to be required, well, not required, let me strike that. You're going to be offered to take the defensive driving course as well. Yeah. Based on the nature of your charges, I have an offering here that does not, that only covers 1, 2, 3, 4 of your offenses. So there's an updated offer in the file, and the most egregious that I have here is a reckless driving.
And what is the offer on that, Your Honor?
that's not encompassed in this offer. So I believe that you may have gotten that charge recently, and that wasn't in the file.
I'm guessing it was all one oh no, maybe not. It's two different
No,
officers.
it wasn't one incident. She's got plenty of matters here before the court, and that matter was had before these other matters. So I don't know why that didn't get that didn't get encompassed in this. But be that as it may, ma'am, you have the you have the opportunity to sort of redeem yourself in so many words against that allegation of reckless driving. That's a 6-point offense. That is a mandatory 90-day driver's license suspension. And you do have another 11 to 15 over. So for that reason, typically in this court, if you want some relief on those offenses, then you're going to have to take Michigan defensive driving course. You're going to have to take this course, and as Mrs. Ladisinski did, you're going to have to bring some substantive information to the court in order for us to, for my city attorney to be willing to grant you any relief on that. I'll tell you that the more substance you bring, the better the offer will get. But based on that, you have the ability to plead straight up. I'm right now handing the file to Attorney Goss, and he's going to update that offer, and I can relay that offer to you once he does that. But I can guarantee you that he's not going to give you any relief on the reckless driving unless you take the Michigan defensive driving course.
Okay, I took the Michigan defense driver's class, so I got to take it again.
No, you don't, ma'am. When did you take that course?
You told me I had to take it before today. I've been taking it. I took it last month.
Do you have proof that you?
I got a certificate on my phone that I passed.
Excellent.
Let me say this. Let me ask you to email me that certificate. So I guess you're going to be prepared to let the court know what you learned about the class as well, right?
Yes.
Where? Right, well, let me I'm sending you my my email address is in the chat now. Email me that certificate. I'll add that to your file, and when I get that information, we'll recall your case, and and then he'll update the offer, and we'll go from there. Okay.
Okay.
All right. So, Mr. Silverstein, let me recall the case of Aaron Michelle Ladisinski. I gave you an opportunity to speak with Mr. Goss. There was an offer that you understood would be available to Mrs. Ladisinski, which would be to dismiss the defective windshield ticket and to amend the offer to blockading traffic. I don't know if there's been some more discussion regarding that.
Yes. Oh, go ahead, Mr. Prosecutor.
Dante Goss again on behalf of City Detroit. Your Honor, we just spoke, and he decided for the blockading also that you would be responsible for the windshield.
Okay, very well. Is that what you understand, Ms. Ladisinski?
You're muted, Aaron.
Sorry, yes, Judge.
All right, very well. Can you raise your right hand, please, ma'am? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Ma'am, you understand that you have a right to a formal hearing in this matter?
Yes, I do.
You understand by taking this off, you're going to give that right up?
Yes, I do.
Has anybody offered you anything other than what was stated in the record?
No, sir.
All right, let me draw your attention, ma'am, to April 12th, 2021 at around 3:27 p.m. in the city of Detroit, in the area of Lafayette and Libby Street. Ma'am, did you have an occasion to be pulled over by a Detroit police officer on that day?
Yes.
And on that date, were you pulled over? Were you pulled over for speeding, ma'am?
Yes.
And you were pulled over for speeding because in fact you were speeding, is that correct, ma'am?
Yes.
Okay, very well. I'm going to accept your responsible plea to the amended count of blocking traffic. I'm going to fine you $175 on that matter. And ma'am, were you operating a 2016 Subaru?
I was.
And on that date, was there something wrong with the windshield on that vehicle, ma'am?
I had a crack in it.
Very well, ma'am. I'm going to accept your, are you satisfied, Counselor, to both of those factual bases?
So satisfied, Your Honor. I would just indicate for the record that the windshield has subsequently been repaired.
Very well. I'm going to accept your plea, ma'am, responsible plea to the block for the defective windshield ticket. I'm going to fine you $120 in that matter. Ma'am, when can you pay?
I can pay today.
Very well.
Well, how do I do that though?
Okay.
Can I pay online or?
Well, 1 second, Your Honor, I just want to put on the record that Officer Robinson was in agreement with this offer.
Okay, Officer Robinson, are you still there?
No, Your Honor, that's why I put it on the record.
Very well. And today was not set for, was it set for trial today?
Yes, Your Honor.
All right, so strike that. I said in the opening that it was set for a free trial, but it was set for trial today. And I do know for the record that Officer Willie Robinson of the Detroit Police Department did appear today. So you can pay today, ma'am. So I'm going to put in the system, just as a control date, the date of August 16th. And if you can't pay by, at the very latest, August 16th, I suggest that you zoom in, ma'am, and ask the court for some more time. If you pay today, the matter will be closed out, but you have at the very latest, the August 16th date to pay that. If there's no further questions from you or your counsel, then you both have a very good day. And please slow down, Mrs. Ladisinsky.
I will. Thank you.
Your Honor, I'm assuming it might take a minute for your clerk to put it into the system. So she should maybe hold off for an hour or two before logging in to pay.
It shouldn't take long. It should be in the next couple of minutes. She's going to do that right now. And you can pay if you want to pay, ma'am. If you want to come grace us with your presence at the court, you can do that. Or you can pay at any DIVDAP kiosk in the city of Detroit, or you can pay online at 36districtcourt.org.
Okay.
All right. If there's nothing further, you have a very good day.
Thank you, Your Honor.
You too.
All right, thank you. Okay, Mr. Walling, where are we at with Mrs. Moore?
I was not able to talk to Mr. Goss. I still need to do that.
All right, let's see, Mr. Goss. All right, let's move on. I'm going to put this matter aside here. I'm going to put that matter aside till Mr. Goss steps back in.
All right.
So let's recall the case of Shalonda Layfield. Mrs. Layfield, there's an offer in the file here, and that is to plead to let's see. I think he's got this a little bit wrong here. He does. Oh, I think what I'm reading to is based on, there's a preliminary offer based on you taking the Michigan Defensive Driving course.
Which is?
Well, let me let him redo this because it doesn't seem right. Let me let him redo that. All right, let's move on to the next person. Did I leave my thing in the file?
I'm sorry, Your Honor.
Did I leave my Here, Mr. Goss, what is it? I can't interpret what you're trying to say.
Or this Miss Layfield?
Yes, that's a reckless driving ticket. Which is mystery. Right.
Have you gotten something sent to you by Ms. Layfield, Your Honor?
Have I got what?
Anything sent to you by Ms. Layfield?
I have. Oh, Ms. Layfield has taken the driving course, correct?
That's what she said. She was gonna send you her certificate.
All right. And I have something from Mrs. Graham as well. Yes, I do have Mrs. Layfield's certificate. So, since we're here now, and I guess would be a good time, Mrs. Layfield, for you to have the floor and let us know what you got out of this class. Again, you're being charged with reckless driving, man, which is a 6-point offense, and it carries a mandatory suspension of 90 days. I'm going to allow you at this time to speak, unless you would like to speak to counsel first, on what you got out of this class. The more substantive information, I'm sure the better the offer is going to get. So, Ms. Layfield, if you're ready to go, you have the floor.
Okay, I've learned a lot from this course. I learned a lot of information that I didn't know, a lot of information that I could share with my family and friends. I'm aware of a lot of stuff that I can do now and a lot of stuff that I can't. I'm not a drinker, but I'm aware of the awareness of a drunk driver, so I know what to do when around them. When I got stopped, my car was hydroplaning, so that goes into the road constructions or whatever. And now I know that I need to be aware of my braking distance. I also got stopped for a mirror, and I know how important the mirrors are now. I know that you have to be equipped with a mirror to see up to 200 feet. What else did I learn from the class? I know that on the road, I'm not only driving for myself, but I'm driving for everybody else. I'm more aware of what to look for and to pay attention to. As far as the intersections, that's where the most crashes happen at. So I know when I'm following behind trucks, how far to go and how much time they need to stop, so that I'll be aware of that. I learned a lot from the class, actually. What else? I learned the fines for fake insurance, how much time you can get in jail for that, how much it'll cost. What else? I learned a lot from the class, for real.
All right. Mr. Goss, is there anything you would like to say? Can you put your appearance on the record, please?
Dante Goss on behalf of the city of Detroit.
So let me say this, Mrs. Layfield. So you brought a little bit different information than what we've usually heard about. You said something about the drinking and driving, but you talked about the mirrors and basically the equipment, how important the equipment is on your car. You mentioned about hydroplaning, and that's where it got you into the situation that you're into now.
Yes, sir.
What was it about? Let's give us some more substantive information about hydroplaning. And did he talk about the nature of how those things happen and the causes of those things?
So when it's raining, I know that your tires float on the water. So it's better to stop ahead of time than to stop right in front of a car or in front of a red light, because you're not going to be able to. And that's what happened to me.
Did it talk about when the rain and when the driving conditions are most hazardous when it rains?
Yes, sir.
All right, what did it say in relation to that?
It just said that you need to be aware of your braking distance and aware of everything around you.
But did you recall it saying that the first 15 minutes of the rainy period is the most dangerous?
Oh, yes. I'm sorry, yes.
And why is that?
Because the rain coming down.
No, ma'am. You gotta pay a little bit more attention to the course, ma'am. It said because the first 15 minutes, the rain is mixing with the oil at that time.
The oil on the ground, on the road.
Saying like that, ma'am?
Yes, sir.
And the first 15 minutes, after that, it kind of washes it away a little bit more, but the first 15 minutes are the most active times when it's raining. Did it say something about the distance away from a vehicle that you need to be traveling when you're following behind someone?
No.
Now, I'm not convinced that you got everything that you needed to get out of this course, because it does state and give you a lot of information as it relates to that. And those are kind of conditions from what you tell me that you're here for.
Yes.
That you were here because it was wet outside and that your vehicle went out of control because of the hydroplane. I do have your certificate here in taking the course. I will say that I understand that some people are better articulating what they learn than others, and not because that they didn't get as much out of the course as others did. Is that you may be a little bit nervous, I'm sure, while it's not necessarily putting you on the spot, you knew this ahead of time before we got here, because I'm sure that was explained to you when you were offered to take the course. So I will note that you took the course. I don't have the updated offer, but I will give the city attorney a chance to speak, and I'll give your lawyer a chance to speak on your behalf, and I'll even give your lawyer an opportunity to go in a breakout room with the city attorney so he can see if he can negotiate the best offer that he can for you.
Okay.
For the reckless, she take a 2-point box. We get 2 point. It's a little bit better than the actual speeding violation, and she also have a plea to guilty. Failure to display the tinted window. Dismiss 1, 2, 3, 4 other matters. You know what? If she take, I would dismiss the tinted window. So if she do failure to display no options, I would dismiss all other matters.
Okay, ma'am, did you hear the offer? Okay, and counselor, the offer is amend the reckless driving ticket to a no ops ticket, which is a 2-point offense. That offense is a misdemeanor. It is punishable by 93 days in jail and up to a $500 fine. However, any misdemeanor, essentially in this court, we just ask that you pay the $240 fine. Also, you mentioned that a failure to display, which is also a misdemeanor, it doesn't carry any points, but it does abstract to the city, to the Secretary of State. That would be another $240 fine. And with that, all other matters will be dismissed.
Okay.
So just to make sure I'm clear, Your Honor, reckless is being amended to no NOP, and she's pleading failure to display, and everything else gets dismissed. Is that correct?
Correct. Correct.
Ma'am, jump on that, will you?
Yes, sir.
All right.
So I just paid 2 tickets, right?
Well, not only are you just paying 2 tickets, ma'am, you're walking away with a heck of a lot less points.
Yeah.
And the fact that your driver's license is not going to be suspended for mandatory 90 days. So
Additional 90 days suspended already. So
additional 90 days. So, ma'am, it's my understanding you want to take that offer today?
Yes, sir.
All right, very well. Ms. Layfield, can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down, ma'am. let me ask you this, ma'am. You understand you have a right to a trial in these matters?
Yes.
You understand by taking this offer, give that trial right up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
All right, Ms. Lakefield, let me draw your attention to January 14, 2021 at around 4:07 p.m. in the city of Detroit, in the area of Gratiot on Whitthorne Street. Ma'am, did you have an occasion to be pulled over by a Detroit police officer on that day?
Yes, sir.
And were you asked to provide a valid driver's license?
Yes.
And you couldn't do so, could you, ma'am?
No.
And why is that?
Oh, I didn't have it with me.
Okay. And didn't have it with you, that's going to meet the requirements of the display. But you didn't have a valid driver's license because it was suspended right now.
Yes, but I didn't.
That's why you didn't have it with you, right?
Yeah.
All right. Let's. I'm gonna find you guilty of the admitted count of failure to display a valid driver's license. And ma'am, let me draw your attention to October 23rd, 2020 at around 3:23 a.m. in the city of Detroit. Ma'am, did you have an occasion on that day in the area of Connor and Harper to be pulled over by a Detroit police officer on that day, ma'am?
Yes, that was the reckless driver.
Yes, and tell us, ma'am, on that day, tell us what happened, ma'am.
On that day, I was coming home from work and it was raining, and I was trying to stop at a red light, but my car wouldn't stop. So it turned to the right, and I turned it back to the left, and then finally stopped and got stopped by the police.
Were you speeding on that day, ma'am?
No, sir. Not at all.
And are you saying that you ran the red light, ma'am?
No, I didn't run a red light. My car stopped directly in front of the red light.
I'm trying to, Mr. Walling, I'm trying to create a factual basis. I don't have ROA for this reckless driving ticket, which that concerns me because I don't have anything to wire Ms. Layfield on to create that factual basis. But so far, the factual basis hasn't been made. There needs to be two underlying offenses that will substantiate a reckless driving charge. And so far, there's at best one. I asked Mrs. Layfield if she ran the red light. She says no. I asked Mrs. Layfield if she was speeding. She says absolutely not. I call that any question, but we'll say that based on her testimony today, I don't have enough for the reckless driving, which is really the most concerning offense. What I can do for your client, sir, is I can give your client a trial date unless you can, and I can give you and your client an opportunity to go in a breakout room and figure this matter out. But so far, I don't have.
Why don't we do that now, Judge? Have me go into a breakout room with this young lady, and let me figure out what we can do here.
But I'll tell you though, I'm particularly concerned about just having the ROA, Mr. Walling, because you know, this is not this is not it's not going to be something that, put it this way, if they don't have the ticket at trial date and actual, so we can create the factual basis, then she'll be found not guilty on that. Because of the rules of evidence and all of that, we're not going to proceed off an ROA in this courtroom.
Well,
so I don't know why it's not.
I would concur with the court As long
I
as.
don't know why it's not in the file. This matter was before the underlying matter that I do have copies, that I do have copies of the tickets here. So based on that, I'll give you an opportunity. We couldn't create a factual basis on the reckless driving. There's only really at most one matter that would constitute reckless, and as you know, there needs to be two underlying matters. I don't have the actual ticket in the file.
All right.
And I'm going to give Mr. Walling and Mrs. Layfield an opportunity to discuss this in the breakout room. And we'll see if Mrs. Layfield wants a trial date set. Yes, Your Honor. All right, join that room, please.
Well, it's not whether she wants a trial date, because it's whether she can make a factual basis. And I believe the court is saying you're uncomfortable at this time doing that because you only have an ROA.
And I don't, and based on not only just that I don't have an ROA, based on Mrs. Layfield's recollection of the offense, that's what I'm basing it on. If she can give the court, meet the elements of reckless driving in her in her factual basis, then I wouldn't have a problem proceeding with that. But she hasn't done so.
And I'm assuming you will allow me to voir dire the witness.
I will allow that. If you want to do that now, after you speak to her in the breakout room.
Yes, I think I need to see her in the breakout room.
All right, before you go to the breakout room, what are we doing with Mrs. Gore?
I'd like to talk to Mr. Goss in private.
Okay, very well.
And we tried that, but for whatever reason, I couldn't get through to him.
All right, let's speak to Mrs. Layfield. Let's take care of this matter. Then you're going to give you an opportunity to speak to Mrs. Gore, and then we're going to move on to the next Mr. Cortez Green. So join that breakout room. She's waiting on you. Ms. Layfield is waiting on you now. All right, Mr. Green.
Yes, Your Honor.
You've taken the Michigan Defensive Driving course as well.
Yes, sir.
This is the city of Detroit versus Cortez Carl Green, case number SP 1136519, counts 1 and count 3. The court will note that Mr. Green had a drove left center ticket that was dismissed by party. Okay, I thought that there was some sort of fine paid on that, but based on that, there was a dismissal, so we won't even go over that matter. So, Mr. Green, there's a preliminary offer in the file to plead to the amended count of limited access 60 and a 55. But as you know, we will offer you an opportunity to discuss what you learned out of that class and to see if that offer can get any. So, Mr. Green, based on that, if you're ready to speak, then the court is ready to hear, and people are ready to hear what you have to say.
Yes, Your Honor. I first like to say that I really didn't think I was going to pass the course on several occasions. And at the end of the course, it really shocked me that I had to take another 25-question test. I honestly thought I was going to not ever pass that. I actually took the test 3 times before I was able to pass it, and I actually did it at, I believe it was 2 o'clock in the morning, and I did them back to back to back because I did not want to go to sleep and forget, which I do have a problem with my memory, and that takes me to the course of what I did learn during this program that I took. I am a victim of a drunk driver hitting me as a pedestrian back in 2006, which injured me very badly. I'm just now having surgery on my lower back where they did a cage fusion in 2018. They also did a fusion in my right hip, an SI joint fusion in 2019. Also, I need to have surgery on my neck because I have herniated disc in my neck that bothering my left arm where it's going numb and tingling a lot. But the major part is that I have an enclosed head injury where I forget very easily. And that's where I really was having an issue at with me taking this course. And that's why I was reluctant the first time me and you ever talked, that I did not want to take the course because I know how my memory is. I'm going to forget very easily. But I took the course, and to my recollection, I was able to remember some of the things and be able to pass it. It took a while. I believe you said that the course takes up to 14. There's 14 classes, about 14 hours. It took me over 20 hours to do this. And I am glad that I did take it because I learned some things. I can't say that I remember everything. I do remember some things like the seatbelt issue with making sure everybody is wearing seatbelts, and the easiest person in a vehicle get injured is a small child if they ain't got no seatbelt on, and it becomes the very first projectile in a vehicle. And me personally, I done had kids, and I have friends with kids, sisters and a brother with kids, and I see how a lot of people don't be having their kids seatbelted in, and I'm always saying to myself, that does not make sense. The kids need to be buckled in, period, just for their safety. Now, when the law first came out, when we had to wear our seatbelts, I was against it. But as many accidents that happen and kids that got hurt, I really, really believe that law has a strong ground to stand on. Also, the part with the drinking and driving, which touches me even more so than anything. I'm sorry, Your Honor, I don't have you on screen.
You don't have me on the screen? I'm listening, sir.
I do now. What touched me more so than anything out the course that I remember a little bit about is the drinking and driving, where it takes 1 hour to your body to process. I believe it was one ounce of alcohol, which is a legal limit of 0.08, whereas the legal limit. So every hour your body processes 1 ounce of alcohol. And if you drink more than 1 ounce of alcohol within an hour period of time, your body is not going to process it. You're going to blow over the legal limit. Now, I also had that issue throughout my life too. When I first got struck by this person that was drinking and driving, where I had turned to alcohol. Because I had to do something to help me with the pain that I was in, because the medications that I was getting was not helping. And I started drinking a whole lot. I was drinking a half a gallon of liquor a day. And I would get behind the wheel and drive. And I thought I was the best driver in the world. But now, today, looking back on that, I realized I was just an idiot. Here I'm doing the same thing that caused me the pain that I'm in. And here I am, I'm doing it. And I can get into an accident and hurt somebody like what happened to me.
Now, let me say this, Mr. Green. I can appreciate the fact that, first of all, you've brought something to this court, and we've been doing this since I've been here in the May, beginning of June. I've been listening to people that have taken this course, and you brought something to this course that hasn't been brought since I've been here, and it's about the seatbelt. I guess we both probably grew up, we're the same age, practically a couple months older than me. But but we didn't have to have that seatbelt off for a long time while we were driving and while we were kids, but that came about, and I guess everybody was a little bit reluctant to adhere to that. And you're right that if, especially the backseat passengers, they automatically become projectiles when they're not seatbelted in there and it crashed, and they just project themselves to the front, and that's often very injurious to not only the person that is getting thrown to the front of the vehicle, but also people that are in the front of the vehicle. They're likely to get hurt as well. So that's something that hasn't been brought to this course, and I can appreciate the fact that you took the drinking part very seriously, and you realize that you not only jeopardize yourself, but you jeopardize the lives of everybody that you're on the road. I think you have to realize when you're on the road, I know sometimes it's frustrating. You know, people are trying to cut in and do things that maybe they shouldn't be doing, but the road is for everybody. Everybody is really in a rush to get to places. Everybody loves to go hang out and party and stuff like that, but they need to take it very seriously when you get behind the wheel, or don't get behind the wheel when you're drinking and driving. And I will say, sir, too, that your memory seems to be okay. You indicated that your accident way back in 2016. That's about 15 years ago, and you laid it down on. 2016. That's 5 years. My city attorney corrected me. 5 years ago, but you really laid out what your injuries were and that. But based on that, sir, I don't have your certificate. Do you have a certificate? Did you get that certificate?
Yes, sir.
Can you email me that certificate?
Yes, sir.
All right, I sent my email address in the chat. If you go down to the bottom of the screen and hit that chat button, you'll see my email address. Until I get that certificate, I'm going to pass the matter, and I'm going to recall the case of Mrs. Jamila Gore. Okay, Counselor, on Mrs. Gore, I give you the opportunity to speak with her in a breakout room. I did.
Need to talk to Mr. Goss about Ms. Gore.
All right, let's talk to Mrs. Goss about Mrs. Gore.
Layfield.
Huh?
He spoke to Layfield.
Okay, he spoke to Layfield.
Right.
Okay, all right. Where are we with Mrs. Layfield?
Ms. Layfield is ready to proceed to accept the people's offer.
Okay, so Mrs. Layfield, back on the record with Miss Shalonda Layfield. Ma'am, we're at the point of taking a factual basis so that you can resolve these matters. Ma'am, can you tell us what you did on October 23rd, 2020? Or Mr. Wallen, you can go out there your client.
Thank you, Your Honor. That was 10/23 of 2020.
It's around 3:23 a.m. in the city of Detroit, in the area of Conner and Harbor.
3:23 a.m. All right, Ms. Layfield.
Yes, sir.
May I direct your attention to October 23rd of 2020 at 3:23 a.m. Now, is it fair to assume at 3:23 a.m. it's dark outside?
Yes, sir.
And you have indicated to the court that it was raining.
Yes.
And you've indicated to the court that it was raining in such significance that you, in fact, were losing control of your vehicle due to the fact of hydroplaning. Is that correct?
Yes.
And is it fair to assume then, ma'am, and would you agree that you were going too fast for the conditions that were available?
Yes.
So you were not acting in a prudent manner with regard to speed in this manner?
Yes.
And is it true, ma'am, that the people behind you, because of your having to lock up those brakes when you got to that light, they had to take drastic action to keep from rear-ending you?
Yes, sir.
So is it fair to say, ma'am, that at that date and time, considering the conditions, you were operating that vehicle with a willful and wanton disregard for the safety of others, including yourself?
Yes.
And is it also, ma'am, would you say that because you were in violation of the basic speed law?
Yes.
And would you also say, ma'am, that you were, because of the way people had to take a drastic action to stop, you were in fact blockading traffic at that time? Is that correct, ma'am?
Yes.
Your Honor, I am satisfied with all the information I have gleaned from my client that you've got enough for the to take a plea on the original charge. Frankly, though, John, Your Honor, I think you could have taken a plea to the amendment and that would have sufficed. But I will leave that to another discussion.
Let's, I'll accept your plea to the amended count of no ops. So Mrs. Layfield, I'm gonna fine you $240 in that matter. That is gonna impose additional license suspensions. However, ma'am, that's not $480 today. What I will do for you is I will waive any warranty fees, ma'am, but I'm gonna hold you responsible for any reinstatement. Stipulation of probable cause, counselor, I will dismiss the other matters.
So stipulated.
Okay.
So ma'am, when can you pay?
I can pay today.
$480 today, ma'am?
Yes.
All right, I'm gonna put in the system August 16th, 2021, just so that if you have any trouble with that, you'll be able to have at least at that time to pay that, ma'am. And I will say this, ma'am, please, I appreciate you taking the class and taking the course seriously. So please slow down. And if there's nothing further, Mrs. Layfield, you have a very good day.
You too. Thank you.
Thank you very much.
Judge, if I may, this is Attorney Kevin Bassant.
Yes.
Judge, once again, I'm here on Nikolai Gore. We adjourned this matter. Once again, it's close to 10 o'clock. Unfortunately, my client has not signed on. I've contacted him. I've been in contact with him. He knew about today's date.
All right, very well. Let's call the case of Nikolai Gore, case number U563876620. Can you put your appearance on the record, please?
And good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Nikolai Gore.
Okay, today is the date and time set in this matter for a pretrial. We've given counsel and his client an opportunity before he was here. It was set for a pretrial, I believe, for a week or two ago, and Mr. Gore has failed to appear. He's failed to appear at this time. So what I'm going to do is I'm going to issue a bench warrant in this matter for a $500 cash or surety bond. With the cash or surety
Thank you, Judge.
Thank you very much.
Thank you, Your Honor. You too. You have a great day.
All right. All right, let's move on let's allow Mr. Walling an opportunity to speak with Attorney Goss regarding Mrs. Graham. And I believe Mrs. Graham has provided the court with a driver's license. Can we run that driver's license, Madam Clerk, for Mrs. Carolyn Rosette Graham? And also, she's provided proof of insurance for a 2019 Lincoln. I don't know if I have her file.
It's for this afternoon, Judge. And it only looks like it's for a no insurance misdemeanor.
Oh, for no insurance misdemeanor?
Have you seen her insurance, Your Honor?
No, I haven't.
Okay.
So that's on the chart?
No,
the only thing on the docket, 1:23 p.m., which I thought was rather odd anyway. But that's Sabrina Grab, right? Sabrina?
No, Carol.
Carol. Is she on today's docket?
So, no, she called in. So let's call the case. This is the City of Detroit versus Carolyn Rosette Graham, case number SP 1165982, counts 1 and 2, and SP 1166271. I have a operator's license not on person. I have a valid registration and a prohibited left turn. Mrs. Graham has provided the court with certificate of insurance of registration. That would be for a 2019 Lincoln. Also, Mrs. Graham has provided, we have run Mrs. Graham's license, and I will say that there is absolutely nothing on this license that is valid. So it's prohibited left turn, no valid registration, and operator's license not on possession. All right, so Mrs. Graham, the offer today, are you there, ma'am?
Yes, sir.
The offer today would be to the amended charge of blocking traffic, ma'am. That's $175 fine. That's amended from the prohibited left turn. I don't know what happened on that day with the left turn, ma'am, but that if you want to resolve the matter, I'll allow you to plead to that and charge you $75.
Your Honor, may I say this?
Ma'am, I don't want you to speak to the facts of the case. If you want to do that, I can put you in a breakout room with Mr. Walling, but that's the offer today. If you want to contest the matter, then you can get a trial date. You can set that up now.
Well, Mr. Walling has no clue what's going on with this, other than what you said, Your Honor, because she's not on the docket for today. So
understood, Walling. So I just gave you all the information that you necessarily need to know.
Okay.
So Mrs. Graham, do you want to take that offer, or do you want to fight this matter, or do you want to speak to Mr. Waller?
Well, who is Mr. Waller?
I am the lawyer of
today. That's your attorney. That's the attorney for everyone today, if they don't have their own.
Well, I would really like to pursue this matter because the left turn sign was just recently
Let me stop you, Ms. Graham. I'm going to give you I don't want to hear any of your testimony. That's going to be for October 4th, 2020, trial date. At 9 a.m.
You say 2020 or 2021?
No, sorry, 2021, October 4th, 2021. That's going to be the date and time for a trial. On that date, you need to bring in, well, you don't need to do anything. The state has to do it, or the city has to prove you guilty beyond a reasonable doubt. but I would suggest that you bring in any information supporting your claim, so the defense lawyer at that time, unless you bring in your own defense lawyer at that time is equipped with something to defend you in the matter, okay?
Okay.
October 4th, 2021. Have a good day.
You too.
Make sure your cases get found for that day.
Yes.
All right, let's go back to Mr. Cortez Green. Mr. Green, there is a certificate in the file for you that you completed the defensive driving course, and the offer now is to plead to the amended count of blocking traffic, correct?
Yes,
Fine you
sir.
$155, sir. There's a no point offense. That's just like an expensive parking ticket.
Yes, sir.
Would you like to take that offer, sir?
Yes, sir.
All right, can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down, sir. Sir, you understand you have a right to a trial in these matters?
Yes.
You understand by taking this offer, you're going to give that trial right up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
Okay, Mr. Green, let me draw your attention to November the 18th, 2020, at around 9:40 p.m. in the city of Detroit, in the area of Schaefer and Mecca. Did you have an occasion to be pulled over by a Detroit police officer on that day?
Yes.
And on that date, sir, were you pulled over for driving left center of the street or careless driving, sir?
Yes.
And what did you do as it relates to that careless driving?
I was traveling, I believe it was eastbound on Plymouth, and made a left onto Schaefer Avenue going, I believe, north. And I was driving in the center of the yellow lines.
And you knew you weren't supposed to be doing that, is that correct, sir?
Yes.
All right, I'm going to accept your plea to the amended count of blocking traffic, sir. I'm going to fine you $175 in that matter. When can you pay, sir?
Today.
All right, I'm going to say August 16th, just for the computer purposes. Please get that paid today. We can get this matter closed out with the stipulation of probable cause. I'll dismiss the other two matters, Counselor.
I'm sorry, Your Honor, I can't see you on the screen. There's somebody else on the screen.
I was talking to your lawyer. With the stipulation of probable cause, I'll dismiss the other two matters.
Okay.
So, Your Honor, do I still need to talk to Mr. Whalen in the breakout room?
Mr.
Whalen, do I still need to talk to him in the breakout room?
We're talking about Mr.
Door.
Okay, don't wait for him. I'm headed there now.
All right. $175, sir. If there's nothing further, great day. Be safe.
All right, you too. Thank you.
So Mr. Miller was substituted in the case, and I have
that.
It's nice that he is under order.
Who's that speaking on while court is in session? Is that Mr. Stevenson?
Yes, sir. I just logged in, Your Honor.
Yeah, well, do you have something else going on in the background, sir?
Just a fan in my room. That's all, Your Honor.
Well, somebody else has something else going on in the background. I'm going to ask everybody to please mute your phones until I call your name.
Yes, sir. Thank you.
All right. Well, you gotta probably help me with this first name. Mr. Laskar is,
Good morning, Your Honor. Nuralam Lasker.
Nuralam, I was gonna say that. This is the city of Detroit versus Nuralam Lasker, case number SP 824037, counts 1 and counts 2. And SP 9391281. Also, 214806071. All right. Let's see. So, Mr. Laskar, you've I hate to say it, sir, you've signed up yourself for 4 points on your driver's license by paying that 26 to 30 over. I don't know what you're doing driving 26 to 30 over. I guess that's on the freeway, so that's at least one thing. It's not on the surface street. But you signed yourself up for 4 points on your driver's license by paying that ticket. That goes back to 2018. So, with that being said, based on the fact that you have paid that, the court is willing to offer you a plea to the amended count of failure to display. That's a $240 ticket. And then the court will dismiss all the other matters.
Thank you, Your Honor.
I can put this aside to see if there will be some better offer from the city attorney or not, or you can take that and pay it and close it out, or I can set up a trial date. What would you like to do? You want to wait and see if the offer can get any better, sir?
If possible, you.
Pardon me?
I didn't hear you, Your Honor. Say that one more time.
You want to wait to see if the offer can get any better, sir?
Yes, I would love to do that. Yes, if possible.
All right, I'm gonna put the matter aside. Okay, we have I believe Mr. Stevenson, Attorney Stevenson, and are you here? Good morning, Mrs. Rogers and Mrs. Stevenson. Are you here on the same matter?
Good morning, Judge. Yes, that is correct. We're both here on Warwick.
Okay. And I don't see Warwick.
It's on 10 o'clock.
Second page. I don't have it. I don't have the 10 o'clock page.
Oh, sorry.
All right. What are we? Wait on. Let me call this case. This is the city of Detroit versus Joanne Warwick, case number U561622120. Appearance for the record, please.
Good morning. Sydney Rogers for the people, page 2072.
Okay. And Counselor, your appearance, please. Mr. Stevenson? Mr. Paul Stevenson? Is he frozen? Mr. Stevenson, are you there? Obviously, he's not either paying attention or his system is frozen. I see that he has a microphone on and his video is on, everyone can see him. I'm gonna call Mr. Paul Stevenson. Do you have your client's contact, the opposing counsel's contact information, Ms. Rogers?
Let me look at my cell phone. I believe I do. I do. I will give him a call.
All right. All right. Please just see if you can text him if that does. Mr. Stevenson. I can't imagine what he's doing. Who's on the Galaxy J7 Prime?
I believe that's me, Jason Loterzo.
All right. Good morning, Mr. Loterzo.
Good morning, Your Honor.
Hello? Hello?
We're calling your name, counselor.
Who is this, please? Oh, very well. Very well. Okay, I'll try to log in. I logged in, but I don't know, 10 minutes ago, and I was told that. Okay, very well. I'll try to figure out how to do this. Bye.
All right. Judge, we were speaking on the cell phone.
We can hear you very well, sir. I don't understand why you can't hear us.
Come on.
Mr. Stevenson. I've never had this problem before.
Let's do this. Come on. Oh, come on.
All right, we're going to pass the matter and move on. Mr. Walling is in there with Counselor. We have Mr. Laskar is going to wait on his updated if he can get a better offer.
Judge Perkins, it's Sydney Rogers. Can I go to another courtroom briefly while we wait on technical issues?
Yes, you may.
Thank you, Judge.
Judge, this is Paul Stevenson.
Mr. Stevenson?
Hi, you doing this morning?
Are you there, sir?
Yes, I am. Can you hear me?
Okay, Mrs. Rogers, I can hear you. Can you put your appearance on the record, sir?
Yes, sir. Paul Stevenson. My P number is 34075, appearing on behalf of Joanna Warwick.
Okay, where is your client, sir?
I think I see her listed on the screen.
Okay.
But she's not, she always participates by phone and not by computer, so you may not see her face.
No, Mrs. Warwick, I see her on the screen. Can you unmute yourself and start your video, please, ma'am? All right, while we're here, let's say for the record, the last time we were here over a month ago, we had Judge, who is now retired, Judge Deborah Langston, on the case as well. I've assumed this case, I've assumed her doc. The Judge Langston was supposed to bring me the entire file, and I reached out to her after that, and to the date, I haven't gotten the file. Let me say that. Let me say also, Mr. Stevenson, you were going to email me a motion for an evidentiary hearing, and to date, I haven't received that motion for evidentiary hearing.
Your Honor, if I may.
If someone would like to update me on whether there's some sort of resolution or what's going on with this case, I would certainly like to hear that.
Sure, Your Honor. Your Honor, the motion to suppress and quash the arrest and for an evidentiary hearing was already filed several months ago with the court. And if you haven't received a copy of the file yet from the court clerk or whatever, that's unfortunate. However, if you need another copy of the motion to be submitted to you, I'm more than happy to do that. And I can do that today. But the question that's before the court on this motion is whether there was probable cause warranting the warrantless arrest of my client, Joanne Warwick. And really the response of the people, response to the prosecution has not met that question. And I can supplement that question. In fact, you know, the prosecution's position, Your Honor, is that Ms. Warwick does not have a right to an evidentiary hearing as to the legality of her arrest. And there's so much Supreme Court, Michigan Supreme Court and United States Supreme Court case law on that rebuts that position of the city. It's almost, forgive me for using a pedestrian word, laughable. But Your Honor, if you haven't received the court file yet, obviously we're not in a position to discuss this in a meaningful way. So I could easily submit copies of the motion to suppress and quash the arrest this afternoon by email to whatever email address I'm provided, and copy Ms. Rogers, who already has this material. She's nodding yes, I can see that. Yeah, there we are, Your Honor.
Okay, so let me state for the record, the last time we were here, I understood that today there would be, I would have an opportunity by now to have reviewed the motions. Mr. Stevenson, if I recall correctly, I gave you that email address last time, and you said you were going to send that to me, but I never received that. So with that being said, I haven't also received the entire file, which even if I did receive your motion, sir, I would want to see and update myself on the entire file, so I probably wouldn't have had a ruling today anyway, because
Sure,
I haven't got
that. Yeah.
So based on that, Madam Rogers, do you have anything to put on the record?
Yes, Judge. First, do you have my response, the people's response to the motion for evidentiary hearing that is dated June 9th, 2020? Thank you, Judge. So yes. I don't believe you need anything else.
The court is in possession of the plaintiff's response to defendant's motion to suppress the arrest of defendant and to dismiss or quash the complaint.
That is correct. That is my response to Mr. Stevenson's motion. I don't believe you need anything else from the people on this. And just for the record and for all parties to know that the complaining witness, the arresting officer, unfortunately, Daryl Cross, he has passed away, but the people are prepared to proceed without him based on him working with a partner that day.
Well, Your Honor, that is just introduced another level of complexity into this case. And obviously, we need to investigate that. But notwithstanding, defendant's motion to quash the arrest still pens. And by the way, just Your Honor, because my client does not have a computer face.
Well, your client does have the ability. Your client.
Right. Your Honor, let me just explain.
Let me speak, Counselor. Your client is on the line now. I've asked your client to unmute herself and to start her video. She has appeared to sign on by computer because I see that there is capability of audio and video. If she was calling in, that would reflect that she would just be on the phone and I wouldn't see the video icon or the audio icon. So based on that, I've asked your client to unmute herself and I've asked your client to provide video. So we excused your client the last time from not being here, and I want your client to. I want to at least see your client's face, counselor. I don't even know who your client is. I just know her by a name.
I get that, Your Honor, and my understand,
Now your client, Mrs.
May I just briefly respond?
No, not yet. Attorney Warwick, can you hear the court? Okay, your client has unmuted herself, and so she's taken one step. I am trying to call Joanne Warwick.
Give her, Your Honor, my client has certain health issues which affect her ability to participate. So if we could just be patient a little bit. It's difficult for the court sometimes, but if we could be patient with the court.
Now this is the first level.
Ms. Warwick, Ms. Warwick, are you there?
Counselor, this is the first time I'm hearing your client has health issues. I don't know what your client's health issues are. I do know that.
Your Honor, it is not necessary.
We can't talk at the same time, Counselor. And we're not going to do that. I do know that I waived your client's appearance the last time, and I didn't ask for too much in the way of a reason why your client can't appear. I see that your client is online, and I see that your client is taking the step to unmute herself. And I'm going to ask your client to also provide us with video so I can see who your client is. Normally, this is a misdemeanor case, sir. Your client has to appear before the court. And if we weren't in the conditions that we were in, meaning that we're in court through Zoom, then your client would be in court in front of us.
Your Honor, let me say this about that. My client has appeared dozens of times in courts before, in this court, before 4 prior judges or 3 or 4 prior judges, every single time without a bench warrant. She is very invested in this case. She's not ignoring the mandate of this court to appear. And to suggest in any way that she is not participating in this proceeding today willfully would be totally inaccurate. And I even think that Ms. Rogers, the city prosecutor, could concur with that part of the facts in this case, that my client has always been there for the court when summoned. Okay?
I would agree with Mr. Stevenson. I'm very familiar with Ms. Warwick. We've probably had about 20 court hearings together at this point. I don't believe she's ever KPS, but I know I don't know if I've ever seen her on Zoom, but I've seen her countless times in person at 36th District Court.
Just, by the way, Your Honor, I received a text message from Ms. Warwick. She says, I'm trying to do this. She's trying to figure out how to unmute it, but she's not good with this. And that's one of the problems I'm sure you've experienced, Your Honor, as a lawyer and as a new judge. People learning technology. This is
no. Listen, Counselor. I did not indicate in any way. You brought up the area of bench warrant. What I said was that, of course, I'm a new judge and I'm new to this case. What I said was the last time I let your client waive your client's presence without any reservation, counselor. And this time I see your client is online, and I see your client has provided video, and at one point unmuted herself, and now is muted again. All I ask, and now your client has unmuted herself and muted herself again. All I've asked is that I see your client. This is my first time ever, will be my first time ever seeing and hearing your client on the record. I didn't suggest anything about the last previous 20 or so times that she's here. I'm only talking about what I have, my experience with this case.
Sure, Your Honor. And you know what? It's clear, I think, from the on and off clicks. We've probably all had this problem where we're trying to figure out how to navigate technology, and I can see her like you. She's clicking on and off and clicking on and off, and yeah, I'm kind of wondering. Okay,
sir, get the cigarette out your mouth, sir.
Hello.
All right. Very well. I'm sorry for the interruption.
I don't smoke. I don't smoke cigarettes, period.
No, I'm not. I wasn't speaking to you, Counselor. Mrs. Warwick, can you hear me now?
Joanne? Hello?
All right, I'm gonna pass the matter until your client gets her.
Sounds good. I'll call her on the sideline. Thank you, Your Honor.
We're ready on Gore, Your Honor.
All right, let's go with Mrs. Jamila Gore. Let's see if I called the case. I don't know if I called this case, Madam Clerk.
Never have. No.
No, Your Honor, and can we just go off for a few seconds? I just want to change the case.
Yes.
Thank you.
Joanne? Hello? Hello?
Please mute yourself, Counselor. We don't need to hear your side conversation. I will say, Counselor, that it's best your client get it together now, because she's going to be we're going to have to see her. Obviously, this case isn't going away, so she's going to have to get it done in the future.
Judge, is it possible that our next hearing be in person, or is the court not doing in-person hearings yet?
Yeah, I think we can have it in person, especially seeing the
Stop
technical.
with the criticism of the judge. Just tell me about the technology problem.
Your Honor, I'm ready.
Okay, very well. Let's call the case of Jamila, City of Detroit versus Jamila Charmaine Gore, case number SP 1139579, counts 1, 2, and 3. Hear it for the record, please.
Yes, Your Honor. My name is Philip X. Walling, representing Jamila Gore. Are you there, Ms. Gore?
Yes, I'm here.
All right, Your Honor, I've had a long conversation with Mr. Goss, and I don't know if he and his paperwork has made it up to you, but as an officer of the court, my understanding of the people are going to dismiss all these counts.
Dante Goss, on behalf of the City of Detroit. That is correct, Your Honor. The people are willing to dismiss the 2 counts. Yes,
Actually 3. Mrs. Gore has there was a motion on the floor. I don't know if it was she filed that motion or handwritten that motion or just gave an oral motion to the court, but I was on the expired plate ticket. I am willing to set that ticket aside, that default judgment aside. It was have during the pandemic. So
that's fine, Your Honor.
So, and the basis for that dismissal, Counselor?
My wonderfully persuasive argument, Your Honor. In the interest of justice.
Right. Based on that, and hearing no objection by the city attorney, We're going to dismiss the matter. Mrs. Gore, if there's nothing further, ma'am, we're going to waive any fees, and we'll also waive any reinstatement fees if there are any, okay?
Okay, so how long will it take for my license to be reinstated?
Ma'am, that's it's going to be a question with how soon the Secretary of State gets that. You know, I would say that at least wait 72 hours. We're going to put that in right now. It should go immediately to the Secretary of State, but I've seen delays up to 72 hours. So, and I won't suggest that that's going to automatically be reinstated. That I would say that you would need to go and deal with the Secretary of State after that. All I can say is we're going to issue the dismissals in and submit that to the Secretary of State. Okay, perfect. So my record is clean. Well, will be. Well, the 36th District Court, I don't know what you've been doing out there in the other jurisdictions, man. So. Oh no, nothing. Then that means it's all clear. Okay, perfect. Do you by any chance know any way to cancel a registration after a car is sold? Because I know Secretary of State is kind of giving me the runaround. I'm like, how do I stop this from happening? That's going to be a legal matter. You might want to hire Mr. Walling for that. I don't know.
No, thank you, Your Honor. Have a nice young attorney.
All right, he wants you to find a nice young attorney. He wants you to find a nice young attorney. So, all right. All right. Thank you all so much. All right. Let's see what Mr. Jonathan Goodwin suggested that he has to get to work. So based on that, and he's a call-in. Who? Goodwin. He's a call-in. He was supposed to be here last Friday, and he
another person not on the docket.
Another person not on the docket.
Okay.
I had technical problems on Friday afternoon.
Mr. Go, I'm calling your name, sir. This is the City of Detroit versus Jonathan Riley Goodwin, case number SP 1158269, counts 1, 2, and 3. We're dealing with an improper plate, a defective brake light, and a defective windshield or defective equipment in some kind of way, defective bumper, fender, or windshield. There is an offer here to plead to the defective brake and dismiss the other two matters. I will fine you $200 for that defective brake ticket. Would you like to take the offer, sir, set a trial date, or would you like to speak with the city attorney?
I was under the impression these were going to be fix-it tickets, and I had fixed both of them. I have documents to show that all things were fixed. It was a windshield, but it was not in the line of the driver.
Okay. Is there, Mr. Goss? Do you have proof of that, sir?
Yes, Your Honor.
Can you email me that proof, please? What about the plate? What about the plate, sir?
Yeah, it was during the pandemic. I put the plate on. I know ignorance to the law is not an excuse.
All right. Well, now you're going into
current registration, sir, for the vehicle.
I do. Yes, sir.
Send that with those documents to the court.
All right. I'll put my email address in the court. I'll put my email address in the chat. You've been on here a while. I'll retouch that. Send me those documents with the proper plate and the proper and the fact that you fixed those matters. And we'll get back with you and recall the case. Mr. Goss, Mr. Laskar, recalling the case of Mr. Laskar, he has a driving while license suspended ticket. I wanted the court to know that he paid a 2018 civil infraction just recently that I'm sure caused him 4 points on his license of 26 to 20 over. He was waiting to see if he could get a better offer, but as at some point, that civil infraction will have dropped off his record anyway. So, and he paid a no registration ticket at that time too. And he paid a disregarding a red signal ticket. So, with that being said, sir, the offer's going to stay the same. You have plea to a failure to display, $240, and we'll dismiss the other matters. I see that you paid this stuff. The 2018 ticket of speeding was indeed back in 2018. It's only going to be on your record for 3 years, so essentially there's no reason to for you to not pay. And then with your disregard for the speed limit, with your disregard for the traffic the traffic signals, with your just disregard of driving, period, we're just going to leave the offer as it is. $240 failure to display, and that'll be an abstraction on your license. That will be additional 30-day suspension. And you can take that offer, or you can take this to trial.
I'll take the offer, Your Honor.
All right, can you raise your right hand, please?
Yes, sir.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down, sir. Mr. Lascar, do you understand you have a right to a trial in these matters?
Yes, Your Honor.
You understand by taking this offer, you're going to give that trial right up?
Yes, Your Honor.
Has anybody offered you anything other than what's been stated in the record?
No, Your Honor.
All right, let me draw your attention to February 2nd, 2021 at 2 p.m. in the city of Detroit, in the area of Finland and Savinsky. Did you have an occasion on that day to be pulled over by a Detroit police officer?
Honestly, I really cannot recall, Your Honor.
You're gonna have to recall to take this deal, sir.
You said it was on Finland and Sobieski?
Sobieski, yes.
Yes, I believe, yes. I do recall the area, yes. I'm pretty sure, yes, sir.
So you recall being pulled over by a Detroit police officer on that day, sir?
Yes, Your Honor, yes, I do.
You were driving a 2003 Lexus?
Yes, yes, I perfectly.
And on that day, did the officer ask you to provide a valid driver's license, produce a valid driver's license?
Yes, Your Honor.
And you couldn't do so, could you, sir?
No, sir, it was suspended. I apologize.
All right. You don't, no need for apology, sir. I am going to find you guilty of the amended count of failure to display. I'm going to dismiss all the other matters, sir. I'm going to waive any warrant. With the stipulation of probable cause, I'll dismiss all the other matters.
We'll stipulate it.
All right, so I'm going to waive the warrant fees in these matters, but you're going to be responsible to pay the reinstatement fees, sir. When can you pay?
I can pay it today if you would like me to.
Very well. I would like that. I'm going to give you till August 16, 2021, just for the computer purposes, sir. Just keep in mind, I'm only concerned about the $240 today, but you're going to have to pay the reinstatement fees, which I see as three reinstatement fees of $45 in order to approach the Secretary of State, or at least get clearances here in the 36th District Court.
Okay, Your Honor. So I just paid the Secretary of State, is what you're saying?
No, you'll pay this. That money will go to the Secretary of State. You will pay that money to the to the 36th District Court. Each one of those $45 fees. I just wanted to let you know that you wouldn't get a clearance until you do so, so you wouldn't be able to get a driver's license. Can you turn it down?
No problem, Your Honor. I'll get a ride to the court today after work, and I will take care of that myself today.
All right, and sir, please slow down and follow the rules of the road. You're not the only one on the road, sir.
Yes, sir. I apologize, Your Honor.
Very well. Have a great day if there's nothing further.
Thank you. You have a blessed day yourself. Thank you very much.
Thank you. I'm in receipt of Mr. Goodwin's documentation. I do see it says an application for vehicle title. It is a registration for some kind of Buick 2003. And I have a receipt for a cracked windshield and brakes.
Blinker module.
Blinker, is that blinker? Yeah, repair, replace blinker, repair, replace windshield. Okay, blinker module. All right, with that being said, Mr. Goss, is there a motion? Or Mr.
Move to dismiss.
Mr. Wallen?
Move to dismiss because of compliance.
Okay.
Dante Goss on behalf of the city of Detroit. No objections, Your Honor.
All right. Hearing no objections, the matters are going to be dismissed, sir. I will say this, if there's any reinstatement fees, I don't know, let's make sure.
The car has since been totaled. The transmission stopped working. But
all right, so that's I'm not concerned with
there
cars.
it is. Hi,
So,
everybody.
The matter's going to be dismissed.
Thank you so much.
On camera? Yeah, now I am.
Stop talking, Ms. Warwick.
All right. Dismiss all those matters.
Thank you, Your
All
Honor.
right.
Thank you, Your Honor.
All right, if there's nothing further, Mr. Goodwin, you're free to leave.
Thank you for your time.
Very well. We're recalling the case of Joanne Warwick, case number U56162110. Strike that. U5612. Strike that. U56162120. All right. We've now have Mrs. Warwick on the line. She apparently has figured out her technical difficulties. And I have Attorney Rogers for the city and Attorney Paul Stevenson on behalf of the defendant, Mrs. Warwick. There was a motion, I believe, or at least a question of whether we can have this next appearance in person. Mrs. Rogers, now that Mrs. Warwick has worked out her technical difficulties, is that necessary? Would you still like to make that motion or what?
Thank you, Judge. I believe now that Ms. Warwick was able to appear and I believe is getting Zoom working, I don't think our next hearing on if there's going to be an evidentiary hearing needs to be in person.
All right. I'm going to say this matter is lingering on for quite some time, and I have to get some information in order to rule, and I haven't gotten anything but the city's response to a motion that I've never received. I'm going to do another one-on-one opportunity and reach out to the judge, previous Judge Langston, to see if that file can be brought to the court, or some way we can get that file picked up so I can update myself on that. But we're going to put this off for a final pretrial. I'll wait till October 4th.
Yes, ma'am.
All right, so we're going to put this off one last time for a final pretrial in the matter.
Okay, thank you, Judge.
Can you check October 4th date? Please.
Yes, ma'am.
If it's possible, if we could do any day of the week besides a Wednesday. Wednesdays are very hard for me.
Okay.
October 4th.
Mhm.
That's a good day.
Okay, the October 4th, I'm being told, is a good day. We're going to mark this as a final pretrial. Counselor, I'm not going to, you're going to have to get that motion to me. I put my information in the chat so that you can get me that information. So I'm not gonna reach out to you and wait on you to get it. If I don't have it, we're gonna proceed without it at the next court appearance, Counselor.
Your Honor, may I speak?
Your device is muted, Counselor. All right, he's muted. Apparently you would like to speak, Ms. Warwick. Can you state your name for the record, please? All right, that device is muted as well.
Oh, hello, can you hear me now?
She chooses to. Counselor, I can hear you now. Counselor, I will say that you have the benefit of an attorney there on your behalf. So he still hasn't unmuted himself. I don't know if he's taking care of another matter or what he's doing, but you know something, we're going to make this an in-person hearing because obviously there's just too many technical difficulties that appear to be happening. I don't understand why we've been in this for over a year now with this Zoom. And I don't understand why we're having all of these technical difficulties now. It's just taking up too much time. So we're going to make that October 4th final pretrial date in person.
Your Honor.
Can you hear me, Your Honor? Can you hear me, Paul? Can you hear Paul Stevenson now?
Yes, I can hear you, Counselor.
Thank you so much. October 4th.
Your client wants to speak.
No, my client will speak through me, period. And if she doesn't want to speak through me, then I want to withdraw as her attorney.
Okay, there you go. So, ma'am, did you hear what your attorney says? I can put you in a breakout room if you want to speak with your attorney, ma'am, but I can't stop you from speaking.
Could we please be put in a breakout room, sir?
All right. So did you get that, Counselor? The next.
Thank you, Your Honor. Thank you very much.
All right, I'm going to put you in a breakout room so you can speak with your.
And Judge, are we going to do the next hearing on October 4th at 10 a.m. again?
If 10 a.m. All right, we'll put 10 a.m. We've been proceeding that way ever since I got here, so 10 a.m.
Perfect. Thank you, Judge. Do you need me to stick around on this?
Yeah, I think you should.
All right, will do. I'll mute. Thank you, Judge.
All right. Mr. Hermes. It's getting ridiculous.
Good morning, Your Honor.
All right, let's, who's your client, sir?
My client is Rana Obeidi. It's a traffic matter, Your Honor. I had a quick question. Do you know if the officer has appeared on this matter? The officer's name was Roger Lee Scott.
Is it state trooper?
Okay, is today and date and time set for a trial in this matter?
Formal hearing, Your Honor.
All right.
Very last one at 8:30.
I see. All right, let's call the case. Sometimes, Counselor, you're gonna have to take the initiative and speak up. I'm lucky I saw that in the chat, but sometimes I miss that. All right.
I appreciate that. I didn't want to interrupt.
Now, well, you better take some time to interrupt it on behalf of your client because I'll give them a half-hour grace period. So, do you understand your client has also a remaining in the park after dark ticket?
Yeah, so I did file an appearance on that as well, Your Honor, but I never got a court date for that. I don't know if we're handling those together. When I looked up the Register of Actions, I don't remember seeing your name on it, or if maybe there was a different judge on it. But if I could address both of those, I'd be happy to do that today.
All right, let's call the case City of Detroit versus Rena Obey, case number SX370215991, which today is the date and time set for a trial in the matter, and SP 1077871, that's the City of Detroit versus Rena Obey, and the State of Michigan versus Rena Obey. You can put your appearance on the record, Counselor.
Good morning, Your Honor. Attorney Sean Herm is here on behalf of Rana Obedi. My plea number is 77620.
Okay, very well. As for the matter, the state matter, today is the date and time set for a trial in this matter, and I do not have. Can you pull that Obedi file, please? The officer is Trooper Lee Scott, Roger Lee Scott, in the court today. Roger Lee Scott. Hearing no response, I am going, today is the date and time set for a trial. Would you like to make a motion, Counselor?
Yes, Your Honor. In light of learning that the officer has not appeared today, and I did check the participant list multiple times throughout this morning, I did not see that officer's name anywhere on the participant list. So I'd like to motion to dismiss the matter.
Okay, motion here. It is now 10:46. The case is set for 8:30 a.m. And the court gives a grace period of only a half hour, which I think is much more, but very suspicious for an officer to check in. It's now 10:46. Hearing no response from the officer, and even at this point, even if the officer did check in, the matter is going to be dismissed. As it relates to the SP 1077871 matter, Counselor, there is a warrant out for your client's arrest. Would you like to address that?
Yes, Your Honor. As stated before, I wasn't aware that we were handling it today, but my client is ready to appear in court. If we can get a hearing date to address that matter, I'd ask the warrant be lifted. She has retained counsel. She's had a few outstanding matters that I've been addressing for her, Your Honor. She's tried to get her life back in order. She's trying to do everything she's supposed to do. I know she made some mistakes, for example, not appearing. The fact that she has a warrant out for arrest shows that she's made some mistakes. But like I said, she's definitely doing everything she can to try to address these things.
All right. Is your client here today, sir?
Your Honor, my client is not here today. As stated before, we thought it was just for the civil infraction today. So she is not attending at this moment.
Okay. I'll recall the warrant. I'll enter not guilty on your client's behalf. I will also set a pretrial date in this matter for October the 4th, 2021 at 8:30 a.m. And your client is going to need to appear, Counselor.
Absolutely, Your Honor. I will make sure she's there on the 4th. Is it in person or on Zoom?
It's on Zoom.
Perfect.
There's nothing.
Thank you, Your Honor.
Very good day.
You as well.
All right. So we have, we're back on the record with City of Detroit versus Joanne Warwick. I've given the opportunity of Mrs. Warwick to.
This counsel is present. Your Honor, can you hear me?
Yeah, I can hear you, sir. I've given an opportunity to speak with your client. How do you want to proceed?
Your Honor, actually, given the prosecutor's disclosure that one of the key witnesses against my client has died, I would ask the prosecution to agree to a dismissal with prejudice of this case. There are only so many witnesses in this matter. From the discovery that my client has received on responses to Freedom of Information Act requests, and proceed further with prosecution, in my opinion, and I've been a lawyer for almost 40 years, and this could be the most egregious violation of a defendant's constitutional rights to confront her accusers if the city decides to proceed with this frivolous case. My client was beaten. She was beaten. She was smashed to the concrete outside of the city county building, and but for the fact that she was wearing a day pack on the front of her chest, it would absorb the concussion of her officer's use of force. She might have broken an orbital bone in her eyes, chest fractures, and jaw fractures, and so on. But at any rate, Your Honor, this will need an in-person evidentiary hearing to dispose of this frivolous case for lack of probable cause for arrest. So anyway, sorry to protract, but my client has been texting me during this proceeding, and I'm trying to distract to read this stuff that she's sending me at the same time while communicating with you.
All right, listen, this is taking up an awful lot of time, just that really is going to possibly be an adjourned matter. What I will note is that the court has heard a motion to dismiss based on the complaining witnesses' unfortunate and untimely death in this matter. I do understand that the complaint does need to be signed by an officer, what I will say is that the complaint, I haven't seen it, but I would infer that we've gotten this far, that there was a signed complaint by that officer. I do understand that there are possibly other witnesses to this, but I'm going to give you a chance to respond, Mrs. Rogers, to defense counsel's motion to dismiss based on the fact that the complaining witness has passed away.
Yes, thank you, Judge. The complaining witness did, of course, sign the ticket. There are other witnesses are involved in this case that can testify, and we can put our proofs on through the partner witness that was with the deceased witness at the time of the incident. I have searched through the rules of evidence, the court rules, and criminal procedure to see if there is any rule that required the complainant to testify, and I'm not aware of any. If defense can bring one, this would be a different motion, but there just is not one that I'm aware of and can find. And the people can put the proofs on, and we're not dismissing today or stipulating to a dismissal. We'd like the court to hear the motion for an evidentiary hearing that we're opposing at a future date on October, and then potentially do an evidentiary hearing based on the results of that motion hearing.
Your Honor, if I may respond briefly. I do not know that the 5th and 6th Amendments of the United States Constitution have been repealed. The idea that the prosecution is advancing implicitly that because their prosecuting witness is somehow unfortunately passed away, that dispenses with the 6th and 5th Amendments of the United States Constitution. That is beyond the pale. That is beyond the pale. I can't. I've never heard in my whole 40 years of practicing law. I've never heard of such a position. In my
let me stop, Counselor. Let me stop. Let me do this. I do have reservations regarding the fact that the complaining witness has passed away. What I want to do is I want to explore that matter. I want counsel to explore that matter. You brought the motion to dismiss. I will hold my ruling in abeyance in order for you to properly address that matter, Counselor. And really, the question I think the central issue as it relates to that motion is, of course, I'm going to assume that it's a signed complaint because that hasn't been brought up at all. But so as it relates to that signed complaint, that complaint was signed by, I'm going to assume that complaint was signed by the officer that has since passed away. My understanding of the rules of evidence and procedure, that if there would possibly be a case still in effect based on what that signed complaint says, and if the prosecution can proceed without the officer based on that testimony that's in that complaint, then it can potentially proceed. But introducing the fact that that officer can't provide us any more evidence anymore, I don't have any record of anything further of what the officer has said. There's been, my understanding, there's been no other sworn testimony by the officer other than what's been entered into the record where the case started with the complaint. I would like to get some more understanding on whether that complaint will survive based on the officer's untimely death, and whether the prosecution can add additional witnesses to the case to support what now deceased Officer Cross, what's his name, Officer Cross, has alleged in the complaint. So, am I making myself?
Yes, Judge.
Your Honor, may I?
Lastly, Counselor, I'm just going to give you a minute because we got to proceed with other people that have been waiting a lot longer.
Thank you, Your Honor. And I apologize to all the other people who may be waiting in this Zoom room. This is obviously a very difficult time, but what's happened in this case with the officer who wrote the complaint, who has passed away, what you are presented with, Your Honor, is the fact that my client cannot confront and cross-examine pursuant to her Sixth Amendment right and comparable rights under the Michigan State Constitution. Her accuser has died. This case should be dismissed, and if it should, and you know what, Your Honor, if you want to dismiss it without prejudice, so they can scrounge up some other lackey.
Listen, Counselor, I don't know.
Your Honor, please.
Counselor, I understand that there is some issues as it relates to that. I don't know if dismissing the case without prejudice is something that's going to be judicially, it is going to be in the interest of judicial economy now, because I mean, I think that that the only thing that would be done next is just the city attorney possibly just getting another complaint signed by the other officer that she alleges witnessed it. So
City Rogers has the ability to find some perjurer to sign a new complaint.
Okay, all right. I don't think that. Well, let's put it this way: we're gonna adjourn this matter. I will hold that ruling in abeyance for the next time. So if you want to brief the matter, and I'll give Madam. Let's do this. Let's file briefs in the matter, and I'm assuming that I'm going to get those other copies of that motion that you had. I do have the response. Let's say let's say the briefs will be due on, let's say, September the 15th, in around 30 days. Let's brief the matter. That will give, and response to that will be due on September 22nd for the city. So you can brief that new matter on the motion to dismiss. I will review those, and I will review the other documents. Hopefully I will have received the whole file from the previous attorney, which I have not received yet, and we will take all of these matters up in person on October 4th at 10 a.m.
And Your Honor, let me just procedurally, let me address some of the timeline you addressed. Because it's the complainant who passed away, and it's the complainant whose prosecution this is based on, it should be the prosecution who files a motion to permit this prosecution to go forward. So I think the prosecution should be the one to file briefs first, and then the defense.
Well, I'm not going to say that, Counselor. You have made a motion to dismiss.
Your Honor, this is ridiculous. I'm sorry, Your Honor. I don't want to be rude to you. You're a new judge, but frankly, this is preposterous. This defendant is being prosecuted.
Attorney Stevenson, I really don't care what your feelings are at this point. I'm giving you an opportunity. You have made a motion to dismiss, and I'm giving you an opportunity. I said I would hold my ruling in abeyance, and I said that there's potentially some issues with that. Now, if you want to file the motion, then you can file the motion. If you don't want to file the motion, then fine. But that's what I said I'm going to do. If you have the motion here on September 15th, then I will receive that motion, and I will allow the city attorney to respond. And if there's something other than that, then you're just going to have to deal with it, sir.
One other thing, Your Honor, there is still a pending motion to dismiss for lack of probable cause for the arrest.
I understand that, and I haven't received.
Today was intended to be a hearing on the request of the city to determine whether a defendant has a right to an evidentiary hearing on a motion to dismiss for lack of probable cause. And that.
Well, I'm gonna end it. I'm gonna end it now, Counselor. I haven't, and I'm gonna state for the record that I have not received anything to date. It was at this last court appearance that you told me that you were going to give me a motion, and I gave you my email address. You had that address at that time, and I didn't receive anything. So with that being said, the court is going to be adjourned. We'll reconvene in person at October 4th at 10 a.m. You have everything on the record. I allowed you to make a record, and that's going to be it.
There's one thing. No, I don't want to hear anymore, sir. There's one thing. I don't want to hear anymore. The fact that you already have the file in your courtroom.
Attorney Stevens.
With the motion to dismiss.
If you interrupt my court any longer, I'm going to hold you in contempt. Okay.
Your court should have the file.
Attorney Stevenson, if you interrupt my court any longer, I'm going to hold you in contempt. Okay, I have put on the record everything that I understand about the case procedurally. I think I'm being more than fair to you and your client. With that being said, I don't want to hear any more regarding the case. I've allowed you to make a record. That's going to conclude this matter. We will reconvene on October 4th, 2021 at 10 a.m. That's the last time I'm going to say that. Final pretrial. Have a very good day, you and your client.
You too, Your Honor. I hope you have a good day.
Thank you so much. All right.
Oh my.
This is the city of Detroit versus Eric Lamont Garrett L. Case number SP 1090361. Counts 1, 2, and 3, and SP 1090621. Mr. L, there's an offer.
Yeah.
Mr. Garrett L, there's an offer here in the file, sir, for you to plead to the amended count of failure to display. I'll fine you $240 in that matter. And then, and with the stipulation of probable cause, all the other matters will be dismissed. I'll waive the warrant fee, and you'll be responsible to pay the reinstatement fee, sir. And that matter is a misdemeanor, and it carries an abstraction on your driving record, but it does not carry any points. You have a right to a trial, and you have a right to speak to Mr. Walling if you want to talk to him about presenting some sort of defense, or you need more information on the offer as it's been presented. What would you like to do?
No, I'll pay.
All right, can you raise your right hand, sir? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I swear.
Okay. Sir, let me ask you, you understand you have a right to a trial in these matters?
Yes.
You understand by taking this offer, you're going to give up that trial right?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
Okay, Mr. Garrett, let me draw your attention to the June 14th, 2020, around 2:17 p.m. in the city of Detroit, in the area of Madeline and Rex. Did you have an occasion on that day to be pulled over by a Detroit police officer, sir?
Yes.
And on that day, sir, were you asked to produce a valid driver's license?
Yes.
And you couldn't do so, could you, sir?
No.
And why is that?
It was suspended, I believe.
Very well. I'm going to accept your plea to the amended count of failure to display with stipulation of probable cause. Counselor, I'm going to dismiss the other three matters.
We'll stipulate.
All right. Mr. Garrett L., when can you pay, sir?
I can pay today.
I'm going to fine you $203. Everybody can pay today. That's good. I'm going to put in the system, sir, August 16th. So if you can't find yourself, can't get it paid by then you need to zoom back in and ask the court for some more time, sir. If there's nothing further, sir, I'm going to waive the warrant fees, and you're going to be responsible to pay the reinstatement fees, okay? But the reinstatement fees are not going to be a part of this record. That's going to be something that you have to do on your own, sir, if you want to get clearances with the 36th District Court.
I'll take that and I'll go to the Secretary of State for that.
No, you don't pay that right here with the court as well, sir. I just wanted to make sure you knew that it wasn't a part of this order today. All I'm concerned about is the 240. I just wanted to let you know that you won't receive the clearances until you pay those $45.
Okay, is there any, could I get it put in the system any day before the 16th? Or is that the
you can
early?
pay it any before you can pay it today like you did. My clerk is going to enter that into the system right now. So when you see that $240, it may say $285 on that one of them, but all I'm concerned about is the $240. I just wanted to let you know that the $45 reinstatement fees are going to still be sitting there. So you should see $285 and then $45, $45, and $45.
All right.
When you see that, you can go ahead and pay. All right?
Yes.
There's nothing further, sir. You have a very good day.
You too.
All right. Very well. Okay, this is the City of Detroit versus Asia Joy Lindsay, case number SP 1159871. So, Mrs. Lindsay, I see that was dismissed on, okay, you have, okay, you were required to take the Michigan Defensive Driving course as well. Are you there, Ms. Lindsay?
Yes, I'm here.
All right, and basically, what I'm gonna do is I'm gonna wait for the city attorney to come back in, because you also are charged with speeding in 36 and a 30 mile, 26 over, 85 in a 55-mile-an-hour zone. So I'm sure you got some information you're going to provide to the court, and I want to give the city attorney an opportunity to hear that information. So based on that, I'm going to put the matter off until he comes back in. All right?
Okay, that was good.
Okay. Okay, this is the city of Detroit versus Jason Michael Laturzo. Case numbers V1228172, V1228181, V1228191, V122822021, and V1228121. Mr. Laturzo.
Yeah. Good morning, Your Honor.
Good morning. Mr. Walling, there's it basically says 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Basically, there's no offer in this case. Essentially, it's just a plea guilty as charged to each one of the counts. So that's what it says here in the file. I don't know if that's what I see, that there's a bite in this case. A dog bit someone, so I don't know if that has. I'm sure that has some relevance in why there's probably no offer at this time, but I don't know why there's no offer on any of them. I'll fine you $240 per plea. Here's the city attorney now. So, Mr. Walling, can you put your appearance on the record, please?
My name is Philip X. Walling, representing Mr. Laturzo.
Okay, we're on the record with Mr. Jason Laturzo, who has a 4 dog at large tickets and a dog nuisance ticket. Can you put your appearance on the record, Counselor?
Dante Gostin, behalf of the city of Detroit.
Okay, so I have a situation here where on the file it's asking Mr. Laturzo, well, a bit essentially not giving him an offer at all. It's written as pleading guilty as charged to each one of the matters. Is there something extenuating about this that would cause you to not give the offer? I see that there's an allegation that there's a bite in the case. So can you please provide that court with that information?
Your Honor, there's 4 different dogs. They're all accused of biting someone. So that's the issue, Your Honor, that he had no control of the animal. He's someone that's bitten by what animal.
Okay, did you hear that, Mr. Walling?
Yes, 5 different animals. I don't know if they're
4 different animals. 4 different animals. I don't know if they're saying that each animal bit somebody or what. I can put your client in a breakout room, but essentially I mean, I don't know if he wants to plead guilty or if he wants to take it to trial.
Well, off the top of my head, if they make no offer, there's no incentive for my client to plead guilty.
That's what I would say.
I could do 12-month delay, Your Honor.
You said a 12-month delayed is the offer. Pleading guilty as charged, 12-month delayed. I will fine him $240. And in this matter, I would be inclined, to usually on delayed cases, I'm inclined to dismiss upon payment of the fine. But in these matters, I allow the city attorney to see if you know, the purpose for the delay is that they know that Mr. Latorzo has gotten his dogs together, at least that's the allegation. So I will not give a immediate dismissal upon payment. We'll go the whole 12 months.
Excuse me, Judge, is he pleading guilty on all of those?
That's what it says, sir.
So you're talking $100 per?
$240 per. So that's 5 times. So I would say $1,200 if my math serves me correctly on the top of my head. So times 5 equals $1,200. I'm right.
I'm going to talk to Mr. Latorzo for a hot second in the breakout room, Your Honor.
I'm going to provide you with a breakout room, sir, so you can speak with Mr. Walling and you guys can go over the matter. Okay. While that's being done, we'll pass this matter and recall the case of Asia Lindsay. And we passed the matter because Ms. Lindsay, did you take the Michigan Defensive Driving course, ma'am?
Yes, I did.
Can you email me proof of that?
Can I show you on here? I have the certificate that they emailed me actually, or mailed me.
They put that in the mail?
Yes.
Okay, I see that is the certificate. So, Counselor, Mrs. Lindsay was charged with excessive speeding, albeit it's on the freeway, 85 in a 55-mile-an-hour zone. So I'm not as disturbed about that as somebody driving 26 and 30 over on the top street. But there was a opportunity for Mrs. Lindsay to take the Michigan Defensive Driver course. She showed proof of that. At this point, there was an offer in the file to plead to what I wrote was a limited access 65 and a 55. That is a 2-point offense. If you want to do better than that, Mrs. Lindsay, you got to bring some substantive information to the court on what your class has provided you. And you've probably been online all morning and heard other people that have spoken about the course. So hopefully you can provide.
Sorry, Your Honor. I don't mean, it's kind of hard to hear you. I hear something in the background. I don't know what that is.
All right. So what I said was, you have heard all morning, you've availed yourself to the Michigan Defensive Driving course. You understand that the people have amended the offer based on you taking that to a 65 and a 55 at limited access. That's a 1-point offense, Counselor? 1-5? 65 and a 55 limited access. That's a 1-point offense down from a 4-point offense. If you want to see if you can do any better than that, ma'am, you got to bring some substantive information from what class that you learned. So I'll allow you to speak.
Okay, thank you. Some things I learned first and foremost is that speeding not only puts myself in danger, but others around me in danger. In my situation particularly, I was on the Southfield Freeway or the Lodge, coming from class in Detroit, which I'm not very familiar with that area and the highways and freeways out there. So something that I learned from the course is that to be very aware of your speed limit signs and to pay attention to those. In the course, they had a list of the different speed limits for the different zones and districts. I can run through those, which are the residential district. I believe it's like 15 miles per hour to 25 miles per hour. They have the work zones, which are 45 miles per hour. Freeways are 55 miles per hour. Highways are usually 70 miles per hour for trucks, 55. They have a whole list of that. So that's one of the really things that I kind of looked at and to make sure I do and pay attention to my surroundings and what's going on and speed limits and all that. They also talked about distractions while driving, such as a distraction to be on your cell phone, passengers in the car, music, the radio, to try and limit those interactions with all of those things. They recommended keeping your phone close to you so you're not reaching for your phone. They recommended if you do have to use your phone, to stop at a light or just make sure that the vehicle is not in motion. That's a lot of things that I learned during the course. Road rage. I'm sorry.
Go ahead.
They talked about road rage, how that can provoke someone to drive very aggressive on the road, which can put you at higher risk for accidents. Talk about how road rage is a traffic offense and driving aggressive is a traffic offense in many states. That's a lot of the stuff to sum it up necessarily to what I learned and paid attention to during the course.
All right, I listened to that, and what I heard you start off by saying is that you were coming from class and you were not familiar with the road because you don't live in the city of Detroit. But it doesn't change whether you're in the city of Detroit, whether you're in the state of California, whether you're in New York or any other country for that matter, does it, ma'am? There's rules to the road, and what that course outlined, and you said it yourself, is that there's rules to where you can speed, what the speed limit is, even if there's no sign. So I'm not going to accept that as a reason for why you got caught doing 30 miles an hour over the speed limit. You know, at the most, if you said I'm on a highway, this was 70 miles an hour, then it would kind of be understandable if you didn't see a speed limit sign. But in this case, you're doing, the allegation is you're doing 15 miles over that. So I want to just call you on that, ma'am, as not being a proper excuse for having being caught driving that fast on the freeway. But I do take note that you have taken the class, ma'am. It sounds like you got something out of the class. So with that being said, my city attorney is here. I think what we've been doing is giving people the deferences. I don't know what your driving record looks like, ma'am, but we're going to offer you now a blocking traffic, and that's going to be a $175 fine. And you can take that, ma'am, or you can take this matter to a formal hearing. What would you like to do?
I'll take that.
All right. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. All right. You understand you have a right to a formal hearing in this matter?
Yes.
You understand by taking this off, you're going to give up that right?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
Okay, Counselor, will you stipulate to the face of the ticket as an accurate factual basis?
Yes.
All right. I'm gonna, with that stipulation, I'm gonna find you responsible for the amended count of blocking traffic. I'm gonna fine you $175 in the matter. When can you pay, ma'am?
I can pay today.
All right, everybody's got money. So I'll put August 16th in there. If you find that you can't pay that by August 16th, you need to zoom back in and ask for it more time. If there's nothing further, Mrs. Lindsay, please take that class seriously. Slow down, ma'am. You're not the only one that's in a rush to get home and things like that. And how far are you with your studies in school?
I have a year and a half left. I'm in nursing school currently. So.
And you're going to be very much needed. There's a very much shortage of nurses. You're going to find yourself in a very lucrative career, and we want to see you make that. So slow down, okay?
Thank you, Your Honor.
All right, thank you very much. Have a great day.
You too.
What are we gonna do with Mr. Laturzo?
He's going to continue his not guilty plea at this time, Your Honor, and I'd ask the court to go directly to a bench trial via Zoom.
Okay. Trial date, October 4th. I'm being at 9 a.m. She says it's all right. It wasn't that many things on the trial.
I'm freaking.
She looked at it all
long.
Huh?
Water took long.
Oh, in person. We'll just have a long day that day. Because that's what.
Mr. Laturzo?
Mr. Laturzo, I set your matter for a bench trial, October 4th, 9 a.m.
Did you get that, sir?
Yes, I got that.
Okay.
All right.
Is that on Zoom or in person?
That's going to be on Zoom.
Okay, in this meeting hall?
Yes, and if you.
Same bat time, same bat station.
A good, I thought this was a good station here. You know, I thought we were having a lot of good things going on. But anyway, if you, you don't have to prove anything, sir. It's on the people to prove you guilty beyond a reasonable doubt. But I will say, if you have some information to support your, in defense of yourself, you need to have that on that day so the defense attorney can, have something to work with, sir, if need be. All right, if there's nothing further, you have a great day. I'll see you back on October 4th, 2021 at 9 a.m., sir.
All right, thank you, Your Honor. Have a nice day.
All right, this is the city of Detroit versus William Roger Lewis. Case number SP 1138724-1. Ms. Lewis, you had an opportunity, and I believe on that date, the officer didn't show up. There was a trial date set for 8/6/2021, but you failed to appear, so you missed that vote, sir. Would you like me?
I thought it was Fridays. I thought it was Friday, sir. And I had called and I had a problem with my equipment.
All right, yeah, it's not, I don't have any problem resetting another trial date, sir. You're here now. I just let you know that you were winning. You were winning. You basically essentially won, but I couldn't grant you that win because you didn't show up. So you want another trial date, sir?
Yes, sir.
All right, trial date. October 4th, Madam Clerk?
Yes, we don't have that many, Your Honor.
All right, trial date, October 4th, 2021 at 9 a.m. October 4th, 2021 at 9 a.m., sir. Please show up next time. Hopefully, well, for you that maybe the officer has either forgot or is not that interested in dealing with the matter. If so,
thank you, sir.
It'll be dismissed again. I appreciate your patience, sir. If there's nothing further, have a great day.
You too. I'm gonna write that down. October 4th. Okay. Where my pen? Thank you. Have a great day.
You as well.
Yes, yes, sir. It's at 9 o'clock. I'll be there.
Yes. This is
okay. So I can end this. I can end this now.
End it now. You're free to leave, sir. Be safe. Have a great day.
Thank you. Thank you. How do you do that?
I'll remove you.
Okay, says leave right there.
Okay, Mr. Lewis. You've been patient. I appreciate that.
Yes, sir.
Very well. I had a lot going on this morning. Let's call, let me see. Ooh. All right. Let's call the case of the city of Detroit versus Darren Jermaine Lewis, case number Z8081421. And also case numbers 2172463 21 and 217246331.
Your Honor, what is the date of the Z ticket?
The date of the Z ticket, let's see. The date of the Z ticket is 1/20/2021. It was entered in the computer on 2/2/2021.
Okay, could I speak to Mr. Lewis in a breakout room, Your Honor?
Hey, May, I was gonna even order Mr. Lewis to speak to you. All right, Mr. Lewis, join that room, please. Okay. We got an observer on the line. Observer, can you unmute yourself, please? Gone.
That case with the whatchamacallit is gonna be a mess. Yeah, and I talked to her, I don't know what she talked to her, and I told her I'd come by the house and pick it up. I'll bring it down. I'll bring it down. You'll be down there before. Still haven't heard nothing from her since. I'm not gonna go chasing her around.
Hey, what's going on, Congress?
You call us. I'll call you.
All right.
Did we, are we on the record?
No.
Ms. Graham, so she's getting the court date, right?
Yes.
Okay,
Mrs. Graham,
I'll
you're
throw this
recording.
out. This is-
Oh, I'm sorry. Yes, I'm sorry. I forgot. Yeah, you're right. Where she's getting the court date, because she didn't want to take
Right, okay.
that generous offer. She wants to fight a left turn ticket.
Oh, wow, okay.
And then they're probably going to come to court without, I don't know what the insurance ticket or that was about, but
Right.
you're also bringing all that back up too.
Yeah.
She had her driver's license, but I don't know if she had it on her, all of that stuff. Ms. Carway. Gone again. Is that the observer?
Oh, who's observing?
They're gone. No.
We're gonna have someone this afternoon here on a new courtroom clerk. Ms. Consti, I can't think her last name. She'll be sitting in here with us, you know. Probably out in the audience.
Who's gonna be sitting in the audience?
One of our new clerks.
Oh.
They're gonna learn from the best.
All
right, I'm looking at this as Lakefield.
Yeah.
And this is Lakefield. Let's tell you to display.
You want to file again?
And the
I have
NOAA.
to file. I just want to get it right. And okay, and the
NOAA for records.
display in the NOAA.
All right.
Okay, so
See, Your Honor, I listened to you.
what?
About last week, I listened to you. Instead of doing 3, I did 2.
Yeah, I mean, you know, I understand that there's a difficulty in trying to be fair with everybody. You know, cases present some things, but she took the issue to be surprised for us. And then we know the people that are willing to do those things obviously are appreciative. But then we got the other ones that we got 20 or 25 misdemeanors and they get 4 or 5 like, and they don't. At least I almost say they don't give a damn because they're here now, so they
Yeah,
probably.
but look how long it took them to come.
Yeah. And I respect the fact that, you know, sometimes these things get
to the point where it gets unbearable. And when it rains and pours, it just follows, this stuff just goes along. But, yeah, it's cool.
So when would you do the bench trial for this high BAC? Do not say October 4th.
All right, Mrs. I'll rely on.
Please, because
So, give another date?
yes, because that's
I think
gonna
we
be
got
too
like,
much.
yeah. So she want a trial date?
I'm here at Mrs. Nash's mercy. So if she says that's a good day, then we're gonna leave that.
I would like to do like one or two, especially if they got a lot of tickets. I just put that one person on.
Yeah, but
You be all day.
right. On war, they keep adding more people on the work one.
And then the walk-ins, not to mention them, because they come in sometimes too.
No, I'm talking about Warren
Oh, yeah.
on October 4th. That should be just
That's
them.
just them.
I know, but just
Morning,
people.
noon, afternoon should be clear.
I tried to, but just kept on putting people on there.
But I don't think it's gonna, I mean.
Because that's what I was told, man. Hey, you know, everybody plays their part. I'm playing my part. And
But I tried to bring it to your attention.
I did, and I brought it to Mrs. Nash's attention. And she said it was fine.
Yeah, it's gonna be okay. We got a bunch of reviews. We got like all these reviews just to see if they paid.
I didn't ignore what you said.
We got.
I agree.
I just say I'll do this right here. I'll let you do that right there, and Miss Nash does that right there.
Don't be worried.
And then whatever we do,
we
gotta live. We gotta live with it, right?
We're working as a team. We're not
I
trying
know.
to.
I
make
thought it was
anybody
gonna be the
suffer.
worst day today.
Yeah.
Actually, because there's a lot of people zooming in, and then all of that time we took, but we're done basically. I don't know what he's gonna do with that high BAC, but he's been here before.
So this not, I thought it was a show cause. For the guy that Waylon's talking to.
I think it would go well if he wasn't so argumentative.
Who?
The attorney.
Well, he's trying to fight on her behalf, but I'm giving him what he wanted, you know.
He didn't want to write that brief.
Huh?
He didn't want to write that
Too
brief.
bad.
I'm like, you made the motion. How would you make a motion and expect the other person?
And you flipping it now.
Right. You think he's gonna know?
Okay. Let's see, do I need to kick Mr. Lewis out of that room, or you want to go back in there and get him?
I don't need to get him. You can bring him on in if you'd like.
Here he is. Okay, back on the record with Mr. Darren Lewis. Today is the date and time set for a pre-trial.
Yes, Your Honor.
I've given the attorney and Mr. Lewis an opportunity to speak regarding the matter. I think at the last hearing, we probably, there's no updated offer in this case. There was at that time, there was just the open-end talks. And I don't see an updated offer.
Your Honor, I talked to Mr. Lewis. I explained to him the gravity of this matter in the context of 36 district court or traffic courts anywhere. After my discussion, and I pointed out to Mr. Lewis the importance that he retain a lawyer, and he understood that. And I'd like this matter, Your Honor, if we could adjourn for another pretrial so that he can retain himself a lawyer.
All right. I think that I probably indicated that to Mr. Lewis at the last court hearing. Be that as well, let me finish, Counselor. Be that as it may, I do respect the fact that what your attorney today has indicated on the record. And I agree with your attorney that it is a very serious matter in that this is the highest form of drunk driving that you can be charged with in the state of Michigan. That your
subject to up to a year in jail and $1,000 fine. I'm not correct on that, on a high BAC. And you have also an open intox in a motor vehicle. So you got not only one alcohol-related offense, you got two alcohol-related offenses. I don't know if you've taken the Michigan Defensive Driving course yourself. I'm not going to make that a part of what's going on here, but I definitely would suggest that you take that. You've heard a lot this morning. You've been here all morning, and that you saw that that's a big component of the course, and rightfully so. So, with that being said, sir, let's give Mr. Lewis a final pretrial date. Let's give Mr. Lewis a final pretrial date. I have here a pretrial date of October 4th, 2021.
That'd be fine.
Well, I guess it probably won't be final because Mr. Lewis is going to come in with one of those high-powered lawyers that come with all kind of motions and things like that, and he's going to have some zealous counsel that advocates on his behalf. So we're going to just say a pretrial for October 11th, 2021 at 8:30 a.m. I would hope, sir, that you have a lawyer on that date or before that date. And your lawyer knows how to get all the information out of the file and file the appearance and request discovery and things like that, I'm sure. So they'll have an opportunity to at least be up to speed when we come back on October 11th, 2020. Let me say this. Have you been tested at any time, sir?
Tested as far as like what, alcohol?
Yes.
No.
All right. I'm gonna put that component in there.
Your Honor, Dr. also they have City of Detroit. That's why I was up here to request testing and also maybe once a week AA meetings.
Well, I'm not gonna.
This is going on.
I'm not gonna order the AA meetings at this time. I would suggest that you do. I'm gonna order testing once a week, random. Okay, so we'll order testing.
That means no drinking, Mr. Lewis.
That's what that means, and then that means you got to submit to the test too, so we know that there's been no drinking.
But the bond already says no drinking.
Oh, the bond already says no drinking, no leaving the state of Michigan without permission.
I've been gave all that up since that day.
All right, well, we'll see. So is your testimony today that you don't drink anymore, sir?
Yes, sir.
All right. I'll say once a week.
That's cool.
That's once a week is
Is it possible, like, is the testing, is it something on the west side that's closer to me because I'm not driving?
You know, I'm sure there's many different places.
Is there jams on the west side?
Yeah, I'm sure they got plenty of different places. They got some place to take your money on the west side, Mr. Lewis.
I ain't never been in this situation. I don't know.
Well, I hate that you're in this situation, but you're in it now.
Yeah, I know.
How is and I do that for two reasons. First of all, we want to see whether your representation of you not drinking is true, and the best way we can do that is to test it. Secondly, there needs to be some form of oversight because it's a high BAC case, and there's another allegation in the file that there's an alcohol-related offense with driving, open intox in a motor vehicle. So, based on those things, of course, you're if you don't have a license, you're not supposed to be driving, but I don't know if that's the case or not. But at the end of the day, I would say you don't have a license, but that would just be me going on a limb, looking at your past history is in front of me.
Yeah, I had just cleared off all my tickets. This is my first ticket that messed me up. I had just cleared everything with 36th District, everybody. So yeah.
Well, it doesn't appear that you've cleared up everything, sir. You have disregarding a red signal. You are Darren Dermaine Lewis, 2/21/1989. That there is a default judgment on you entered into from a 2016 disregarding the red.
Yeah, that's why I got all my papers right here from 36th District where he dismissed. I had like over 40 tickets since I was 16. So when I went to court, he gave me a whole book of dismissal papers. That's what I have right here in front of me. So I don't know.
You better produce those paperwork at the next court hearing, because it's 2 cases that are open that happen on the same day. That's a no registration civil infraction and a and a disregard the red flash or arrow case that's got to be.
All them tickets came from that same day.
On 2016.
No, see, yeah. 2000. Yeah, I just cleared up everything from the past. I thought you was talking about for 21.
I'm saying it's not clear, sir. I'm saying it's not clear.
Okay, so I produced the papers. I have the papers.
I see a lot of other stuff that's clear on that. It seems like on that 2016 date, but those 2 are still out there. So that's hopefully you have that documentation, and we'll deal with those at that time too. But please do the court and yourself a favor by getting all that documentation and emailing me that documentation too. If you email me that documentation, I would be willing to close those matters out if there's sufficient documentation that says those matters were cleared out at that time.
Yes, sir.
All right, you got my email address, sir?
No, I don't.
I'm gonna send it in the chat one last time for you. It's in the chat, sir. So
I see it. So I can send you those as soon as we get off here, right?
Yeah, send me those as soon as we get off here. I'll put those in your file, and we'll address those matters on October 11, 2021.
Okay.
Share that info with your lawyer also.
Okay. And you say October the 4th at 9?
No, October 11th. October 11th at 9 at 8:30 a.m.
Okay.
It's gonna be a pre-trial.
Okay.
All right.
Yep, I got you.
If it's nothing further, sir, I appreciate your patience and have a very good day, sir. About that testing, will he get in? Will we get in contact with him, or does he need to get in contact with them?
I suggest that I'm going to send this order in, but I can let him know the probation officer. I don't know if he has his son. He can just call the probation department for right now.
All right, write this number down, sir. You got an 8 pen?
I'm ready.
313-965-3414. And I'm gonna order you to call them tomorrow morning.
Okay.
Regarding that testing. Or you can even probably call them this afternoon, but at the very latest tomorrow morning, once my clerk gets that input into the system and they get it over to probation, and I just wanted to have court time to get that over there to them. So at the very latest, call tomorrow morning about that testing, sir.
Okay.
All right?
Yep, I got you.
All right, if there's nothing further, Mr. Lewis, appreciate your patience again, and you have a very good day.
All right, no problem.
On October 11th, 2021 at 8:30 a.m. with the lawyer.
All right, have a good one.
All right, thank you.
Good luck, sir.
Thanks.
All right. That will pretty much do it for today. there's nothing further than
I
Mr.
just
Wallen,
made it official, that's all, just.
I appreciate your advocacy always, and I thank you. And I will see you next time.
Next
sir.
time, Judge. A couple of questions, if I may. If there were more people off the docket than on the docket, is that what I'm going to have to deal with, or is that you expect that to be a short-term kind of thing?
Well, you probably will have to deal with that. I won't say that you won't. I will say that it wasn't more people off the docket than on. That's a little bit of a stretch, but there was a number of people that were off the docket. So what I do and what I've told people that I see out in public that, you know, if you have a matter, then they can zoom in and we'll try to pull their file. It doesn't seem to be a problem until we get a case like Mrs. Warwick's case today that the attorneys want to just, you know, try to overrun the court, and you try to give them an opportunity to put things on the record, and then they want to change their course. So yeah, sometimes you will have to deal with that, Mr. Wallen.
Okay. Just Judge, as our relationship changes, please let me work more so you don't have to work as much.
All right. And how do you propose you do that?
Well, you know, today was kind of a strange day. Trying to think, like as soon as, for example, Mr. Lewis signed in, had me talk to Mr. Lewis, we could have been done with him, you know, in 5 minutes or 10 minutes earlier on in the game, as it were, for example.
Yeah. I will definitely take note of that. What I do and what I'm going to pay more attention to is the people with just one matter. I'm going to start. What I try to do is I try to call them as they come in. So I try to take them in order as they come in.
And I can appreciate that. It's just as a practical purpose that never works out.
Yeah. So what I'm going to start doing is if you have a case where you can see that it's going to just be like Mr. Lewis, an adjournment, definitely you can just raise that at any time and we'll call that matter. And in other matters that I see where it's just one case, then I will definitely take those cases out of turn and call those cases.
Right, and that's fine. And again, part of my situation is I'm kind of getting the idea when the court wants to use the defensive driving thing.